to Azad sir. So if we can begin with your permission.
So who's beginning? Who's welcoming? Who's doing what?
Yeah. So just Basu
Sir,
sir,
we are live.
yeah, okay, we are starting. Good afternoon and welcome to all, ladies and gentlemen. Um, Over the years, the laws concerning the first two terms used in the theme of this conference, that's right to information and the right to privacy, have been known as two sides of the same coin, and evidently they have come in for scrutiny. The Official Secrets Act 1923 is India's anti-espionage that prohibits government site or area which cannot be approached, inspected, or even passed over, and thereby the act provides the protection to the country as a whole. In the evolving business dynamics and new age routes for access of information, as well as laws governing the protection of individual information, privacy, and sensitive data, it is necessary to draw a lucid understanding of the concept of RTI, privacy law, and their expected impact on each other under several subject matters which are of significance today's in this conference, and with special emphasis on the protection and exemption provided in the Official Secret Act 1923. We have made an effort to host this conference, which is virtual, and we welcome our chief guest is about to join soon, Sri Suresh Chandra, Information Commissioner, Central Information Commission, Government of India, former Secretary, Ministry of Law and Justice, Government of India. He will be joining us very soon. For our keynote address, we welcome Shri Yashovardhan Azad, IPS, retired, former Special Director, Intelligence Bureau, former Information Commissioner, Central Information Commission, Government of India. We welcome you, sir. And we have with us Mr. Vasudev Mukherjee, Assistant Secretary General, ASSOCHAM, Mr. Rajendra Kumar, Managing Partner, Kumar Law Associates, Corporate Advisor and Legal Consultant, Dr. Abhay Yadav, Assistant Professor, National Law University, Delhi, Mr. Siddhant Kumar, Advocate and Author. We will be shortly joined by Mr. Syam Lal Yadav, Senior Editor from Indian Express, and renowned RTA activist, Mr. Subhash Chandra Agrawalji will be joining us. We have been joined by Mr. Venkatesh Naik, Director, Commonwealth Human Rights Initiatives, and we will have Mr. Kazim Rizvi, Director, The Dialogue, and Mr. Apar Gupta, Director, Internet Freedom Foundation. So, without further delaying, let me take the opportunity and invite Mr. Vasudev Mukherjee, Assistant Secretary General, ASSOCHAM, to please give your welcome address. Over to you, Mr. Vasudev Mukherjee. Vasu sir, can you please turn your voice on?
Sorry about that. I seem to have been on mute. Mr. Suresh Chandra, Information Commissioner, Central Information Commission. Mr. Yashovardhan Azad, former Information Commissioner, Central Information Commission. Fellow panelists, distinguished guests, ladies and gentlemen. A very warm welcome to all of you to ASSOCHAM's virtual conference on policies, rights and reforms, information privacy, and official secrets. I would like to extend a very special welcome to Mr. Suresh Chandra, who is currently serving as the Information Commissioner at CIC, for joining us today. Mr. Chandra is a person of holistic knowledge, insight, and experience on law and society as a whole. His experience comes from various important roles and positions that he has held in the past, from being legal advisor to the Ministry of Law and Defense.
Hello.
To the
Suresh sir, we welcome you. Chandra sir, can you please turn your cam on? We can't see you. We welcome you, sir.
Mr. Chandra, welcome to the session. We were just highlighting some of your key achievements, and let me continue from there. So from being legal advisor to the Ministry of Defense and steering many important developments to being Union Law Secretary. His work and contribution to the field has been revolutionary. Sir has been awarded and received accolades such as the Scotch Award for achievement of digital monitoring of court cases through legal information and briefing system. National Law Day Award 2016 for outstanding achievements in the field of law and many more. We welcome you, sir. I am pleased and honored to welcome Mr. Yashovardhan Azad to this conference. Mr. Azad is a retired IPS officer and has served as Secretary of Security to the Government of India, former Special Director, Intelligence Bureau, Information Commissioner at CIC. As Secretary, Mr. Azad was the government's top risk and security official responsible for protecting the Prime Minister as well as coordinating the National Crisis Management Group on behalf of the Cabinet Secretary. He has been awarded the Police Medal for Meritorious Services and the President of India's Medal for Distinguished Service. He is a widely published columnist and TV commentator on a range of issues. Coming to the backdrop on the need for this dialogue, I would want to go back to a few historical events that traces the relevancy of this conference. The Watergate scandal in the early 1970s in the US demonstrated the importance of investigative journalism in exposing the government wrongdoing while raising concerns about the use of illegal means to obtain information. In more recent times, the WikiLeaks scandal has brought about brought about by Edward Snowden in 2013, where he leaked classified information about surveillance programs, which raised concerns about the balance between national security and individual privacy, and sparked a global debate about surveillance and the right to privacy. These events and others have contributed to the ongoing conflict between the right to information and the right to privacy and have shaped the legal and policy frameworks that govern these rights today. The themes that we are discussing today not just carry importance and complex issues in their independent nature and character, but also becomes more delicate and intricate when they overlap with each other. In many cases, national security concerns can conflict with privacy and the right to information. For example, the government may argue that they need to collect personal data or monitor communications in order to prevent terrorism or other security threats. However, such measures may also infringe on individuals' privacy and their right to information. Similarly, governments may sometimes classify information as classified or confidential in the interest of national security. This can make it difficult for individuals to access important information about the government's actions, which can make it challenging for them to hold public officials accountable. The key to these conflicts is drawing balance, but how? How is the question that we may delve into by way of this conference. With this, I would now like to invite Mr. Suresh Chandra to deliver his welcome to deliver an address.
Sir, now before Suresh Chandra sir, as per agenda, we have a schedule of Shri Yashovardhan Azad sir for his special keynote address. So may we request Yashovardhan Azad sir to please we welcome you and honor you, sir, and hand over the mic to you, sir. Sir, please turn your mic on.
Thank you for having sorted out your various protocol arrangements and other glitches and things like that. We've already started 10 minutes late. First of all, thanks ASSOCHAM for inviting me to this platform. I have come a few times already before, and some very, very important topics that you've deliberated upon, like internet freedom, privacy, in which we had some eminent speakers like Manish Tiwari, my friend, Karuna Nandi, again, seminars on health. And once again, you've today organized something which is very critical, which is very topical, and I think of extreme relevance to the polity. I must congratulate also for bringing together an eminent panel in which you have some of the people I've already worked with, Shyamlal Yadav, whether it's Subhash Chandra Agarwal, Venkatesh, one of the ever not tiring RTI activist, writer, thinker, and also Kazim Rizvi. These are people who've done a lot of work, and I'm extremely proud to be associated with them. Let me, in my keynote address, go through the broad, agenda, the parameters of this conference, because every conference should have some kind of an objective, some kind of a resolution. Every conference should be for some betterment, and I think no area could be, more critical than this, which we are deliberating upon today. Now, as I start, let me say that since the first RTI, which was filed in Pune police station on October 12, 2005, it has been 17 years, and about time that we look at the whole matter critically. I will not go through those, murky details of what is not happening and what is. I will go through the broad agenda that when this sunshine legislation was enacted, what did people expect from it? Sweden had its first in 1765, 1956, the USA came. In the 21st century that we are talking about, Britain had its first, also the RTI Act. And then when we enacted, after a great history, after a great struggle, which we should never forget, how did RTI come about? RTI came about because of the struggle in the village of Rajasthan, when those panchayats and Gram Sabha started asking hisab do. That means whatever expenditure you are doing, we want to know. We want to know that where the expenditure was directed, it has been spent over there. And this is one of the demands, perennial demands, which has been happening in democracy right through, and even today it is reverberating through the entire democratic system. So the first question is, why is our sunshine legislation so attractive? It's attractive because of two things. It's because of the preamble, which talks about transparency and it talks about accountability. And that is why there were many countries which wanted to learn about this act. In fact, I myself remember going to Manila and addressing those senators out there, giving a lecture at the Centennial University where they asked a myriad questions about the democracy in India, about the kind of system, about the kind of institutions that we are having. So, what are the key questions today we should deliberate upon? What does a common man expect from the RTI? A common man expects the information, everything about his daily needs. He wants to know about rations. He wants to know about bijli. He wants to know about pani. He wants to know about sadak, health, siksha. At a higher level, people want to know about transport. They want to know about roads. They want to know about the system which is around them. They want to know about pollution. And lastly, then there are a group of people who are asking about how government functions. Is it functioning in favor of the people? Should we know more about the PM Care Fund? Should we know more about electoral funding? Should we know more about defalcation of banks, etc.? And that's why it is important today to debate the efficacy of the RTI Act as it has been displayed to us, or it has been accountable to us. Now, the other question is, so when these questions are asked, are they getting the information? The so-called proactive disclosure, which we are talking about, is it coming? Giving loads of information on the internet, giving loads of mountains of information on your website doesn't mean anything. Everyone knows that there are frequently asked questions to a particular department again and again and again. Now, these are the kind of information which are required on the website. The biggest problem I feel, ladies and gentlemen, here is there is a clash between the government servants who think that the discretion of the government is ultimate, whereas the people on the other side, taking the democratic precedence and other principles, are saying no, the government has to be accountable to the people, and therefore the people's questions have to be answered. So ultimately, we come to the question, what are we looking for? When a common man is asking the question, he's not only asking information. You can have thousands of information. How does it help him? So yes, it does border on grievance redressal. And therefore, when commissioners just sort of tell you can't ask a question, why? That's wrong. That's wrong. How can a system help a common man who's asking a question? He's asking a question, बगल वाले को राशन नहीं मिल रहा है, हमें क्यों नहीं मिल रहा है? उसी जब मैं इस पे हूं तो बोलते हैं आप क्यों का क्वेश्चन आस्क नहीं कर सकते. It doesn't mean anything to him then. And therefore, I think to make the system robust, we have to think of ways. What is the way of making the system more robust? One of the most effective ways is to make the system itself a little more strong. Do we have a system today in the Central Information Commission or the State Commission where the system is totally robust? How many times do we plead for vacancies? How many times people go to the court to fill in the vacancies of the commissioners? Are the postings of the commissioners in line with the kind of services they are supposed to deliver? Do some commissioners follow and are capable to their qualifications? I think there are a lot of questions there. Thirdly, the most important thing, the right to information is a very important statute. To implement it, you need commissioners with that stature. You need commissioners to be of the constitutional authorities. You can't say that this is a statutory provision. It's a fundamental right. So the recent amendments, I don't think were in line with what really the RTI Act has to achieve. The commissioners must get their preeminent status. They must get a fixity of tenure. And that's why I think it's important today that when we deliberate upon all this, we must look into the robustness of the system. How's the system functioning? Venkatesh sent me the CIC report in which you see the mounting number of first appeals. What does it show? It shows that the PIOs are not working. And secondly, as I had felt during even my time, is there any accountability for the first appellate authorities? This is something which needs to be seriously looked at. And in the end, let me ask a question. Has RTI in the last 17 years brought down corruption? Has it brought in more transparency, accountability? And especially with this new Privacy Act coming in, the attempt to do away with a very important 81J, modifying it, will it lead to a kind of a blanket ban on answering anything related to corruption? Can somebody's corruption be treated as a private matter? Or it has to be treated aligned with public interest. And therefore, these are issues I hope this will be deliberated upon. Gentlemen, ladies and gentlemen, I mean, a lot of people have given their lives. 45 RTI activists, latest count, I don't know, Venkatesh would know. 45, they have lost their, why did they lose their lives? Because they were asking questions which became uncomfortable to the people. And that's why it's important to uphold the RTI Act today, make it more robust. People ask about electoral funding. People are asking about defalcation at the banks. People were asking why political parties have not become public authorities. We can then ask them, how are you giving ticket to mafia dons? How can democracy function when you give ticket to people who do not deserve it? Why does our democracy throw up unwanted elements? These are serious questions to ask. And RTI is one route actually through which you could have asked these questions. Let me come to privacy. Now, I have an excellent quote which I used even last time when I spoke with the ASSOCHAM. Nothing describes better the absolute right to privacy than William Pitt's statement in the 18th century in England. And he says, the poorest man in his cottage defies all the forces on the ground. It may be frail, its roof may shake, the wind may blow through it, storms may enter, the rain may enter, but the King of England cannot enter. All his force dare not cross the threshold of his ruined tenements. I don't think I need to go beyond to explain the sanctity of privacy. I mean, there is no better way than to explain this. Now, the bill which is coming, I like it. It's very simply worded. That Babu language is not there, notwithstanding, apropos, wherewithal, all these words have been, thankfully, they are not there. It's very simply written. It's short, thank God for that, because most of the government notifications, even I don't understand, being 38 years the government, or 40 years in fact. So, but we have a lot of suggestions. I think CHRI sent in their suggestions. My think tank, Deep Strat, also send their suggestions. And basically, I will just touch through 4, which of course you'll be deliberate upon. The most important thing in privacy is that when my personal data is being used by these, various great fiduciaries, data fiduciaries, are they using it for the purpose they are taking? Is it specified? Have they taken my consent? Or they are also using it for my personal profile? This is the most critical thing. And how are you going to ensure it? That's a very, very important thing. Secondly, there is an enormous discretion with one category of processor of data, that is the government. Now, Puttaswamy judgment had talked about legality, proportionality, and the ultimate, when there is no other way, then you resort to that kind of use of data without giving any explanation. Now, the biggest question here is, how much of discretion, how much of allowance will you make for the government? And can you discuss privacy without the mechanism surveillance? Without the quantum, quality, legality, oversight of intelligence? Isn't it a good time today to discuss whether the surveillance should have a judicial oversight? Is the administrative oversight working? That one officer makes a request for surveillance, another officer of the same rank gives the permission, and then the oversight committee, then the committee which examines it, is just one level higher, and there's hardly in one case where they have rejected the case. Is it time to go beyond it? Is it time in 75 years of our super democracy, which is coming up and aspiring to be a superpower, to change this? Can't we have a parliamentary oversight of intelligence agencies? Aren't the members of parliament responsible enough to be able to look at some of the very, very top secret operations broadly and give their yes to it? It happens in England, where the Prime Minister nominates a set of MPs, and that is how it's done. Is it time to think about it today? I leave it to you to deliberate upon. And ultimately, the clash, which is between the RTI and the privacy, and I will call it a clash now, because if you're talking about modifications in 81J, then the entire crusade against corruption will go. As it is, even matters of transfer in Canara Bank case, as Venkatesh would agree with me, Supreme Court has already said this comes under the realm of privacy. So where is the information going to come from? We have to seriously deliberate on these issues so that we can make a path for the RTI to function. And lastly, the Data Protection Board. In England, it is the information commissioners who handle the Data Protection Board. And I would be very happy to give it to the Central Information Commissioners. It's important because two things. Government is one of the largest processors of data, and government becomes the regulator here. The Data Protection Board rules have been notified. They said everything will be notified in rules. For a very important act like this, I think the Constitution, the powers, the status, and the tenure must have been defined in the Act itself. And I would say, enhance the status of the Central Information Commissioners and let them handle the Data Protection Board also. Give them all the facilities, the backup. In fact, I was one of the information commissioners who agreed to take up even grievance redressal commission, a proposal from the PMO. Others did not agree. Because if you can't do something for a common man, then I think, giving loads of information doesn't help him. Something should work for him. Unless the government, after seeing the information, reacts and takes corrective measures. Hence, the handling of grievance disposal is very, very important. Let me come to that very important thing which you have mentioned. I'll just briefly talk about it, and then Secrets Act. This is the information privacy. Now, we've had a long battle debate on this encryption debate. 69A of the Information Technology Act says that you can decrypt, you can do anything on government's directions. The question is, even from the 90s, during Clinton time, the backdoors were being discussed. The encryption architecture was sought to be penetrated with a Clippers chip in the 90s. It didn't work. It didn't work. You saw the battle between the Apple and the FBI on breaking the code. Ultimately, FBI relented and didn't go to the court. The question is, many people think as a sheer bravado that yes, we can have backdoors to encryption and everything will be hunky-dory. In fact, one of the professors from Madras, IIT, said that. But the experts all over the world say that if you do a backdoor, if you break encryption once, the entire security architecture will break, which means lakhs and lakhs of people using WhatsApp or Facebook or whatever. In a democracy, so you have to take a decision. For one case of terrorism, and I have handled and I have been on the other side too, for cracking one case of terrorism, are you willing to risk the entire encryption security architecture for lakhs of other users? What is the solution? Solution is that the metadata needs to be analyzed much better. And that's why we need more and more the tech companies to collaborate with the law enforcement agencies to get out of this. It has been happening. I'm very happy to say that in some of the cases in Gurgaon and other places, Bombay, they are collaborating to fine tune the metadata and give much better results. Lastly, as far as Official Secrets Act is concerned, my views are very, very clear. I think, in a democracy, in a full-fledged democracy, and we are proud of it, place for Sedition Act, OS Act is no longer there. They should be just thrown out. As it is, OS Act doesn't have any relevance when you have the RTI Act. The RTI Act clearly gives right to information and even says that beyond 20 years, all the information should be given, unless there are some, you stop it on grounds of sovereignty. This doesn't have a place. 1923, it was there for anti-espionage and other things. But it is time to go. And I do feel in an information age, we should be able to get rid of all secrets. I'm sure your conference will deliberate upon all this. You have an eminent panel. I congratulate you and thank you very much for giving me this opportunity.
Thank you very much, Yashovardhan Azad sir, for your deep, insightful sharing of thoughts, deliberations, and we have fairly taken your views and would come back to you for your guidance and suggestions that how, in what manner, further this information can be put forward to concerning authorities and government as well. And yes, absolutely, you have mentioned about this OSA Act. After this RTI Act, there should not be existence of like this, but in the recent past, we have seen the instances, so which give some insights and the and kind of encouragement to further have the deliberations on this, that in what manner OSA Act should exist or should not exist, then what should be the way forward for it. So now let me take the opportunity of inviting our chief guest, Sri Suresh Chandra sir, Information Commissioner, Central Information Commission, Government of India, to please enlighten us. And we are very much thankful. Though, sir, we wanted to host all of you rather through in physical form, but given the timelines and the need, we wanted to host this conference. We prefer to go this time virtually, and soon we will plan some out the bigger event on the subject, which relates to this one as well as a holistic a point of deliberation, and we will love to welcome you again in that physical form. So now I invite and hand over the mic to our honorable chief guest, Sri Suresh Chandra sir.
Thank you. Good afternoon, Honorable former Information Commissioner Shri Yashovardhan Azad ji, Vasudev Mukherjee, Assistant Secretary General, ASSOCHAM, Rajinder Kumar, Member ASSOCHAM and Managing Partner, all the panelists, ladies and gentlemen. I am thankful for becoming a part of this very important deliberation, that is on the RTI, right to privacy, and the reforms relating to the right to information. Though my predecessor, Mr. Azad, has already spoken and covered almost all the points, right from the origin of the RTI movement till the latest development of the Data Protection Act, and as well as all other important judgments. But I shall be failing in my duties if I do not deliberate on all those points which are also important and which has been also touched upon by him. Sir, in the RTI Act, there are 5 elements. That is, the first one, initially when the Freedom of Information Act came, there was no practical regime. So the first element is the practical regime, and this act has brought out very beautifully the mechanism, that is the Central Information Commission and the State Information Commissions. Another aspect is that this is available only to the citizens. And the public authority, because the information which is there, obligation is only upon the public authority. So here, the definition of public authority becomes very, very important. And the right to information, when we define the information, right to information also becomes very important. The fourth element is it promotes transparency and accountability. Because we are a democratic country and citizens must be informed. That's why they have brought out this enactment, very important enactment for bringing transparency and accountability. Now, to what extent we have been successful in after enactment, that is for the deliberation in this conference, and I am hopeful that all those points will be discussed, including the efficiency of the commission's disposal, as well as the most important aspect is that the judgments must be, whatever orders are passed by the State Information Commissions or the Central Information Commissions, these should be enforceable. It is not that the judgments are made one line judgment and the reasons are not properly brought out. What is more important is that your judgment must stand the scrutiny of law, and these must be enforceable. Sir, as I have joined the commission in last 5 years, I have seen our disposal for the first time, even after during the COVID and as well as post-COVID, the disposal is more than the filing, in spite of vacancies in the Central Information Commission. On an average, our disposal, that the Central Information Commission's disposal, is around 3 to 4,000 per commissioner. Average is around 3,500 per annum. And it is also, I want to highlight, because there were certain issues which were highlighted by my predecessor, Mr. Yashovardhan Azadji, about the competency as well as the status. The status is for the government of India to, give. I will not dwell upon that. But as far as the competency level is concerned, I can tell in last almost 5 years, I have not come across any of my order or any of the commission's order which has very prominently figured and which has been reversed by any courts. So this is very important, because enforceability of the orders is also very important. Now, having said all this and discussed this, everybody knows about the statutory provisions, so I will not dwell upon that. But I would like to bring out that the right to privacy as a constitutional right, and the constitutional right has a primacy over the statutory right. Yes, of course, there is a provision under section 8, subsection 3, that if there is any event which took place 20 years before, then it has to be disclosed, that the information has to be provided. Here, I would like to draw attention of the panelists that one case came across for my consideration, and in that there was a special bench constituted for deciding that issue. That matter was, anybody can see, is ASSOCHAM Kutubuddin Siddiqui versus the Ministry of Home Affairs. In this, the appellant had asked for information about more than 12 IPS officers, their details, the recruitment applications, and other dossiers, copy of the dossiers, including the qualifications, etc. And the appellant was none other than the person who was one of the accused and who is still in jail, Calcutta, that 1992 bomb blast case. That matter was discussed at length. And the issue, as our predecessor highlighted, was that after 20 years, the information was to be released. But there is a proviso under that subsection 3, and that says that the decision, if there is any what you call a dispute about the period elapse of 20 years, the decision of the central government shall be final, and that shall be binding. That matter came before us, and the Home Ministry people pleaded, argued that right to privacy is such a right which cannot be brought within the state jacket of this. It is a continuous sort of a right, and it should be protected. And that is how, after our deliberations, we had decided in favor of the Ministry of Home Affairs, saying, relying upon the DS Nakara's case, wherein they have said, when there is a two groups, two classifications, there must be nexus with the classification. And also in the matter of KS Puttaswamy, they have said that there are three elements, there are three parameters for the right to information. Number one, the objective of disclosure, the legal framework, and third one is the nexus between the objective and that subject matter. So, sir, as far as the rights are concerned, I will say the rights are not absolute, but at the same time, balancing has to be done. And I'm happy to share here that in the Thallapalam case, the Supreme Court has also realized that the Central Information Commission or the State Information Commission are the final arbiter as far as the disclosure or non-disclosure is concerned. Meaning thereby, even the courts are not substituting their wisdom. This commission is a final arbiter. But at the same time, it is not that every unreasonable order will be accepted by the courts or by the Supreme Court. There are other issues about the implementation of the right to information. And one is that the first appellate authority, they are not deciding, or even if they are deciding the matters, they are simply endorsing the findings of the CPIO. There have been instances when the CPIO is biased because of the conflict of interest. The CPIO is the holder of that information. At times he is biased, and conferment of the first appellate powers to the first appellate authority was that the first appellate authority will remove that subjectivity and he will pass an objective order. But we have seen in 90% of the cases, the first appellate authority, they are not applying their mind. And apart from that, there is no provision in the RTI Act to penalize them. This is one of the recommendations, apart from other recommendations which we have given. The committee which was headed by me, we have sent some of the proposals. One of the proposal is that there must be a provision for penalizing the first appellate authority wherever there is a either non-application or delay or biasness. So other thing is sometimes there are issues that either the reasons are not given, and somebody if asks the reasons, then the CPIO simply says that it is not falling within the definition of information. In most of the cases, we are asking the CPIOs, you don't give reasons, you give what recorded reasons. Whatever are there in the record, you provide them. Read it, we have read it down, and in number of cases, we have allowed this. The important issue which has been also highlighted by Mr. Yashovardhan Azad ji is relating to grievance. I have realized in my hearing the cases during these 5 years that there is not a single, only few, busy bodies, maybe those who are interested only simply in informations. But the genuine information seeker, at least in 90% of the cases, they have a grievance, and the RTIs are arising out of their grievance. And predicament of the commission is that the grievance is not within our domain. Only the information giving is only given to this. So I'm of the view that even some power, little bit, if not much, as if there is any grievance and the commission realizes that the grievance must be redressed and the grievance is genuine, then at least there may be a power to the Central Information Commission or the State Information Commissions to after having deliberated and discussed the merits, demerits, and give a direction or some sort of direction which can have the persuasive force to the public authorities. Other aspect, see this public authority aspect, somewhere there are certain gray areas, and these may have to be further refined, or maybe wherever there are substantial funding or control. Though in number of cases we are favoring disclosure of information without even declaring the authorities a public authority. But I'm of the view that this will further needs deliberation at your conference level. As far as the IT Act and the Data Protection Act is concerned, I will say once the Data Protection Act comes, maybe the flow of information as well as the responsibility of the custodian of the information will be better regulated. As on date, it is not the case that the information is not available with the public authorities. Directly or indirectly through various means, through Aadhaar, through telephone numbers and details, and bank accounts and financial transactions. Information is in abundance, is available with the public authorities. And the issue which is nowadays is also being debated, whether the Aadhaar related information or Aadhaar may also be shared with the private agencies or private persons. This is also nowadays being debated, and this will also find place. Some provisions will be made. The most important aspect of the personal information, I am of the view that whether it is the public authority or it is a private agency, if it is allowed, the Supreme Court has nowadays restricted that Aadhaar sharing and that information. If this information has to be shared, then it should be limited only to the purpose for which this has been shared by the person. That must be ensured, and there must be heavy penalty for leakage of the personal information or for sharing that information by unauthorized persons. Very important point was raised about the discretion, and the discretion which is exercised by the public authorities while disclosing the information or not disclosing the information. In one of the matters, this matter was also dwelt upon by me thoroughly. And here I have, in my judgment, tried to understand the power as to whose wisdom should prevail, whether the wisdom of the citizen should prevail or the person who is disclosing the information should prevail. That has been dealt with, and I'm of the view, it may be my personal view, I'm saying the sovereignty lies amongst the people. That sovereignty has been used while representing their parliament, members of parliament, or by the state legislatures. The members of parliament have made the law, and the law which is made by the representatives of the sovereign, the law has vested, conferred that discretion on the public authority who is the custodian or who is having that information. I am of the view, unless he acts mala fide, unless he acts subjectively, he passes the order without reasons, and if the order is objective, then definitely the discretion prevails of the person who decides to disclose or not to disclose. Because this is something which will ultimately uh, distort our set rules of the good governance or the governance. There may be hundreds people, 100 citizens, but at the same time, there may be 100 views. As the Plato has said, that the idea of goodness is varies from person to person. So the disclosure of information is done by one person at least in order to rule out that the discretion of the person who discloses should prevail. Thereafter, ultimately, the first appellate authority and the second appellate authority, wherein in Thalla Pallam case, the Supreme Court has also said that the wisdom of the CIC will prevail. So all these issues, I'm hopeful that these will be deliberated by in the conference, and something very important suggestions, as we have mentioned about bringing the first appellate authority within the purview of penalty if he acts mala fide, also enhancing the penalty, because penalty is not very important. Most of the CPIOs, they feel 25,000, even if there is an order, that will be, we will bear with that. And in some of the cases we have seen that instead of the recovery from the personal CPIOs, they are making from the public exchequer. Then again, this is also a loss to the government. And apart from that, I'm of the view that there must be also some certain amendments with respect to the very important aspect, with respect to I will say more powers to the commission. Status, I will not say, but of course, status is also one of the important aspect when enforceability of the orders are concerned. Being a quasi-judicial body which is comparable to the judicial setup, they are not comparable to the government officials. I'm of the view that that should also be, whatever maybe you make their salary less or more, but as far as the independence is concerned, as far as the what you call their comparability is concerned, they should be, if not comparing with the Supreme Court judge, at least should be compared with the High Court judge. That is my feeling. And I think it's a very, very good, important topic, and this conference will come out with very good suggestions. I wish all the best. Thank you for giving me an opportunity and sharing my thoughts. Thank you.
Thank you very much, Suresh Chandra sir, for your taking out your time out for this conference and gracing this occasion virtually. And we look forward to your continued guidance and support and your participation in our endeavors, especially on this subject as well as other subject of your forte in the legal sphere. So thank you very much. And now I
Thank you.
invite Advocate Rajendra Kumarji to please give your concluding remarks and vote of thanks for this inaugural session. And then I would invite my colleague Ritima to please take over the session and conduct the first, second, and third technical session in that way. So over to you, Rajendra Kumar sir.
Okay, thank you, Santosh. So I'll be making concluding remarks and then proposing vote of thanks to the distinguished speakers. I feel the conflict that we talked about is a very interesting conflict because the person who seeks the information has a right to have it because of the freedom guaranteed under Article 19. But the person whose information is sought has a right to privacy emerging from Article 21 and also Article 12 of the Universal Declaration of Human Rights. So I think in that way, it's a very interesting sort of a conflict, but a healthy conflict as well. Now, but how privacy emerges as a fundamental right was already talked about. So, retired Justice K.S. Pottaswamy filed a petition in 2012 challenging the constitutional validity of the Indian biometric identity system of the Aadhaar, as we know. In 2017, by a 9 judges unanimous judgment, the Supreme Court of India, in a resounding victory for privacy, held that the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21. So that is how it became a part of the fundamental right. Now, RTI Act, as others also pointed out, is a beautiful piece of legislation. The preamble to the RTI Act itself points out that Constitution of India has established a democratic republic, and democracy requires citizens to be informed and transparency to be ensured. It adds, disclosure of information is likely to conflict with the other public interests like efficient operations of the government, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. And that, now this is very important, and that it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. So this is actually the directional and how we resolve. So it has to be harmonization or a balancing consideration when we deal with the disclosure of information vis-a-vis the right of the privacy. Now, I know I have the constraint of time, so I would need to. There is a lot one can go on and on, but I would like to confine to be within the time frame. So the Supreme Court. But the other thing is that this act has an overriding effect, and it says it will override any other law, including the Official Secrets Act. So that of course was touched upon. Now, the Supreme Court of India in Rajanarayan case, we know in 1975 itself had ruled the people of this country have a right to know every public act, how the state functions. In SP Gupta versus Union of India in 1981, they said, again the court said, no democratic government can exist without the responsibility, and the basic postulate of accountability is that people should have information about the functioning of the power. But unwarranted invasion of privacy is the exception to right to information, which is enshrined in the Section 8 of the Right to Information Act. So it has to be unwarranted invasion, which is, in the inverted commas. Now, for example, we know Neera Radhia tape case where the 2G spectrum thing, and they said that if it is something to hide a crime, then it is not, we are not going to get a protection. So there's a right to privacy is not secrecy or facility for hiding unethical acts of corruption. And therefore, they said that article no crime could be. So certainly, Article 21 does not have and does not afford any protection to them. There are certain legal principles of disclosure versus privacy which have evolved. There are 4 principles, but I would like to touch upon only one key principle which says unless information in the government hands is non-public and of a highly personal and sensitive nature, such that its public disclosure would be offensive and objectionable to a reasonable person, the disclosure of such information cannot, as a matter of law, violate an individual's right to privacy. So I think the guiding principle is, and in the RTI Act itself, there are there are many examples where they say that it is so whether it is the Central Information Commissioner or the State Information Commissioner, they have to balance that though the information is sensitive, but they have a discretion, as was very aptly pointed out by Sir Suresh Chandra also, that it is at that point of time we have to apply that what interest outweighs, whether it is the interest of the private individual or the public individual relating to his private information, or the interest of the public at large. So if the interest of the public at large is overweighing, then he might allow the disclosure of information. That is this is. I would move to propose a hearty vote of thanks to our distinguished speakers. So, on behalf of ASSOCHAM and also personally, I propose to wish thanks to our participant, Mr. Vasudev Mukherjee, Assistant General Secretary General, in his welcome address and opening remarks highlighted were how the historic scandals took place and what were the overlapping considerations in the conflict of information and the disclosures. So thank you so much, Mr. Basu, for your very pertinent remark. Mr. Yashwardhan Azad also made very significant, captured very significant aspects of the subject. For example, he talked about how this RTI Act came out as a sunshine legislation after a lot of struggle, and it was not, as if something came on the platter, and then how it ensured transparency and accountability. What were the needs of the common man? Common man wanted. He highlighted some of the examples like electricity, water, etc., and how the government is functioning about that. The needs of the government. Then he talked about the efficacy of the RTI Act. He also mentioned about the clash between the government on the one hand, government servant on the one hand, and those who need to who need the information. And he also suggested that the system needs to be made very robust. The commissioners need to be of the stature, and I think he also made a very pertinent gave example of in the England cottage, how the privacy, what is the privacy, and when he compared that everything can enter in the cottage except the king. So that means there can't be any intrusion into privacy. That was the historical concept of privacy. And then he also mentioned about whether there should be a surveillance, should have a judicial oversight, can there be a parliamentary oversight, and he also made mention of the data protection law and also the official secret. He also suggested that metadata needs to be aligned in a much better way. Thank you so much, Mr. Yashovardhan sir, for a splendid talk, bringing out some real practical aspects. Then Mr. Suresh Chandra made in his chief guest address made some key issues, and he highlighted the 5 elements of the RTI. I will not get into that. He already highlighted. Then he also suggested that the judgments of the commission should stand the test of law. So I think which is a onerous responsibility which he is expecting the people to own when they pass the judgment. And he also mentioned that disposal is more than the filing of the cases, so which shows about the efficacy. He also talked about the enforceability of the orders, that not many of the decisions passed have been reversed. So I think which is a good sign, and it indicates that our institution is working efficiently and applying their mind in the right perspective. Then he also talked about the right to privacy as a constitutional right. And some of the things which he also mentioned were about the implementation issues. For example, the first appellate authority, etc., not deciding, simply quoting those things, and there should be some penalty. I fully agree. I have myself been seen this, and when there was nothing, I actually in my appeal wrote also about the penalty. So just mentioning with that. Then he mentioned about the grievances, and that so some of the information seekers are themselves the victim of grievances. But then the question is, the authorities have to have the responsibility to share the information. And he also mentioned about IT Act and the Data Protection Act. And um, and the last point which he mentioned was, of course, he also mentioned that data should be used only for the purpose for which it is required. And then he mentioned about the discretion, I think, which is a very, very relevant point. And the Supreme Courts and the courts have been also endorsing this view that sovereignty lies with the people, and therefore the discretion has to be, must lie. They have the should must have a discretion, unless, of course, that he himself said, malafide or with ulterior motives. So I think, thank you, sir, for your very, very enlightening speech. And I once again thank all the dignitaries for sharing some deep insights on the topics. And it will be our privilege to have you with us, sir, again. And we'll look forward to the same. Thank you. Over to you, Santosh.
Thank you, Rajendra Kumar sir, for your concluding remarks and vote of thanks. And now I hand over the mic to my colleague. Ritima, to please take the proceeding forward.
Thank you so much, sir, and thank you to all the dignitaries in the inaugural session for your thoughts. Now we are moving to the first technical session of the conference, and the session is based on legal jurisprudence, applicability, penalties, and appeals under right to information, right to privacy, and Official Secrets Act. For this, we have two very amazing speakers with us. We have Dr. Abhay Yadav. Briefly about ma'am. Ma'am holds PhD from Center for Law and Governance, Jawaharlal Nehru University, New Delhi. Prior to joining National Law University, Delhi, she served as Associate Professor and Head School of Competition Law and Market Research at the Indian Institute of Corporate Affairs, think tank for the Ministry of Corporate Affairs. Another speaker that we have with us is Advocate Siddhant Kumar. Sir is a lawyer and public policy professional based in New Delhi. Sir has extensive experience in advising on data protection, data flaws, TMT regulation, and intermediary liabilities. Without further ado, I hand over the mic to Dr. Ava. Ma'am, please.
Namaskar, and thank you so much, Ritima, for that generous introduction. Am I audible, visible? Thank you. Thank you. So I thank ASSOCHAM right at the outset for this opportunity. It was a privilege and a pleasure to listen to Mr. Azad and Mr. Suresh Chandra. I follow your work closely in this area, so thank you so much. The scheme of things has been beautifully laid out by ASSOCHAM. So we begin with in the scheme of things with the RTI Act, its connection and its overlap with the privacy, its clash also with the right to privacy, and of course in the backdrop of the colonial, if I may say, the Official Secrets Act 1923. Now, as Mr. Azad pointed out earlier, it's very important for all of us to remember that the Right to Information Act is an act which actually came across and it has been promulgated through a grassroots struggle. So it's a special act in that sense, and the journey of the act has been stupendous as well as spectacular, because for the struggle of accountability in a country as large as India, to begin from the grassroots level, you can imagine how many years it must have taken, especially in the backdrop of a very stiff, a very resistant bureaucracy, as well as a very resistant political climate against opening up of the country, of the bureaucracy and the official records and so on and so forth. So it's right to say definitely that a social revolution, in a manner of speaking, was created by the promulgation of the Act in October 2005. And thereafter, of course, it's been a journey, and I've been fortunate that I've studied the Act from its inception to date. And I've also had some experience with the Information Society project at Yale Law School, where a lot of deep end work was done with the Freedom of Information Act, that is the FOIA of America. So there was a great learning that happened there also. But of course, there are numerous debates, there are controversies that have arisen after the implementation of the Act, especially relating to Section 8. What is personal information? The Act was very widely worded. Um, uh, Lots of interpretations came to be, lots of resistance came to be, and there were, of course, problems from both the sides. And one unique feature of the Act also was the suo motu disclosures that were there. 120 days were given to all public authorities to put the information in public domain. Many of these public authorities were completely, um, uh, you know, the idea of an open bureaucracy was novel to them. So forget about putting it up in the public domain. They didn't even have a website. So from there to be in 2023 and to be talking at a platform like this, where, if I may call it 2.0 of the Right to Information Act, of the Freedom of Information Act, I think would not be wrong. So of course, we've been supported by the judiciary in this entire process, where even before the coming of the Act, the fact that within Article 19, freedom of speech and expression, it was made very clear by the courts that the right to information is an inherent fundamental right of the citizens of the country. This was said again and again in many judgments by the Supreme Court and by other courts, other fora. So that is immensely important. So I feel that this discussion also will be remiss without drawing from the colonial period of the Official Secrets Act, from where the seeds of a closed bureaucracy were sown, and in the manner in which they were carried forward to an independent India. So I think it is important to talk about the Official Secrets Act, so to speak. Also, I feel that democracy has three main pillars, and because being an academician, I cannot not theorize the subject. So we have the three pillars. We have accountability, transparency, um, within which we talk about the Right to Information Act. And accountability itself has two dimensions. There is horizontal accountability of a democracy, and there is vertical accountability. The horizontal accountability, as we all understand, and many scholars have spoken and written about it, is largely concerned with the effective operation of the systems of checks and balances and with due processes in government decision making. And the vertical dimension that I'm talking about, it focuses on elections and other mechanisms that citizens use to control their governments. So the relevant dimension of accountability, both horizontal or vertical, may be different depending upon what our focus is. Is our focus on the elected representatives in a democracy, or the non-elected representatives, that is the holders of public office? For the purpose of this discussion, it is clear that we are mainly talking about the accountability of the non-elected officials. So it is generally assumed that the accountability of non-elected officials, such as civil servants and the bureaucracy, is adequately ensured by the presence of mechanisms of horizontal accountability. There is also the further assumption that members of permanent executive are not directly accountable to the citizens. That relationship of accountability is seen to apply only to the political executive because they are elected by the citizens. So a lot of times we find that vertical accountability mechanisms, such as the 5-yearly elections, are the preeminent instruments of holding elections or elected officials to account. Contemporary discussions of accountability, we find them to seek more encompassing in their coverage of both the elected and the non-elected holders of public office, uh, talking about both the vertical and the horizontal uh, accountability dimensions. But it is the accountability of the non-elected government officials, that is the administrative officials of the state, which is intriguing for the purpose of this panel, because there doesn't seem to exist any other extant mechanism that ensures direct accountability of this section of the bureaucracy. So keeping that in mind, the implementation of the right to freedom of expression and the right to information are established to be prerequisites for ensuring the voice and participation necessary for an open democratic society. This also implies that the promotion and protection of both access to information itself and flows of information that exist between constituents, both men, women, all genders, government, parliament, community groups, civil society organizations, and private sector are of equal importance. And of course, uh, the rise of this act, like I said, has been from the grassroots level and from the micro level processes of civil society, where we had Mazdoor Kisan Shakti Sangathan in Rajasthan, which Sir talked about earlier, which was an advocacy organization that sought government accountability as part of citizens' right to know and right to participate in governance. There was also NCPRI, which was the National Campaign for People's Right to Information, which was formed in the late 1990s, that became a broad-based platform for action. So therefore, after collective efforts of civil society as well as other movements, finally this act came to be. The three distinct terms, open government, transparency, and freedom of information, are often used interchangeably. And of course, many authors have given different definitions, different color to this. Um, but if I were to talk about RTI application, the execution of the application, when an RTI application is received from an applicant, the basic and primary question that a public authority should ask is number one, whether the public authority has the information, and number two, of course, the inherent question that whether there is a desire to share that information. Mostly the answer has to be yes in a time such as today's. Of course, there are exemptions which are provided for within the Act. Uh, and here I'd like to bring on the platform the Canadian experience of Peter Troe, which was a case quite early in the jurisprudence, freedom of information jurisprudence of Canada. Uh, Peter Troe was an electronics engineer who was accused of violating the Official Secrets Act of the country. And this created a furor in Canada over the high-handedness of the government as well as of the entire bureaucracy as far as secrecy is concerned. This was because it was the first criminal trial in Canada that was held entirely in secret, and the image of a Canadian citizen being tried in utter secrecy led led to a lot of media attention and wrath of journalists. Thereafter, we find that there was a huge uh, outcry as far as the Official Secrets Act of Canada is concerned, and then they had to promulgate and also sort of refine their Freedom of Information Act. And similarly, we have found that the Official Secrets Act, like Mr. Azad said in his speech, uh, finds no place in today's modern India, where we are moving towards ease of doing business. We are moving towards a strengthened, more reformed form of democracy. If one were to delve into the international history of freedom of information laws, we find that it is Sweden that has the longest experience with the principle of openness, which goes as far back as 1766. They adopted the Freedom of Press Act, which is one of the basic constitutional laws of Sweden, and it has been there for more than 200 years. But I don't think we should delve too much into that. Um, the normative structure of the Right to Information Act 2005 is something that we all are familiar with. You put in an application with the public authority. You have to know your definitions. Mostly all government offices are public authorities. And we find that initially, when the Right to Information Act was executed, some public authorities came out with certain formats of how an applicant should fill in the application. There were templates created of an RTI application, and then of course the information commissioners were prudent to sort of step in and say that no, you cannot have a template for an RTI application. You actually, as the PIO, as the CPIO or the PIO, you have to assist the applicant in making the most in helping him in framing the RTI questions, and you have to be an enabler rather than sort of, following the bureaucratic structure of having a template for everything. So those are hurdles which we have crossed as far as execution of the act is concerned. Of course, mostly we find that, like Sir said rightly, some sort of accountability at the appellate level, if it were there, it would really help with further strengthening the act, I also feel. And also I feel that the pendency is a huge issue, because a lot of things then get stuck. Redressals, redressal mechanism is not prevalent in the act. Phase 2 of the RTI Act, so many people are talking about, which will be that if you know that the information that you have received as the RTI applicant is unjust, it is on the face of it prima facie, some genuine grievance has been conducted, then what would be your next step? The RTI Act does not provide for that. And then, of course, last but not the least question for today's panel, which is privacy, the privacy issue. So the fundamentals of right to privacy sometimes definitely clash with the fundamentals of the Right to Information Act. And here I would like to quote the author Holm, 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 who has aptly summarized the issue of protection of personal privacy in modern information societies by opining that even before the age of computerization, collection and registration of information was a representation of the privacy of an individual. And information may leak out from a manual file. It may be used for other purposes than those for which it was collected. And the contents of the data may be of such a character that the very registration may be regarded as a threat to privacy. So as a consequence of modern technology, we have sort of given away all of that information to big data, so to speak, and everything is available on the internet at the click of a button. So much of our privacy we have ourselves surrendered to digital media, to digital platforms, be it for e-commerce, be it for our own Google searches. We are literally followed by search engines throughout the day. So in these times, the talk of the clash, so to speak, of the freedom of information vis-a-vis right to privacy is absolutely important. And in the field of digitalization, or the virtual world that we live in, and the meta world also that we live in, it is now to a much higher degree than earlier feasible in a very short time to store, process, and disseminate information on private citizens, companies, etc. And also, although the collection and dissemination of such information in the large majority of cases serves as a legitimate interest, it must be borne in mind that the ever-expanding storing of information on individuals and companies in modern societies, combined with the rapid spread of computer technology, has generated in a general distrust of various forms of data collecting, and it has made the public more aware of the problems with regard to protection of privacy. So we see that so much of our data is available, for example, with IRCTC, so much of the data, Sir mentioned, Mr. Suresh Chandra mentioned the Aadhaar case also. So how to sort of bring all of these issues into line is something which RTI 2.0 will have to think about. I think we are already running out of time. I would like to take some questions at the end. Ritima, over to you for anything else that you'd like me to speak on, or anything. Over to you, basically, Ritima. Thank you.
Thank you so much, ma'am. We have one question for you. So if you can quickly answer that. Mr. Indranil Banerjee says, shouldn't we bring institutions funded by membership and registered under the Society Registration Act under the coverage of RTI?
So the idea is complete transparency, and mostly I find that wherever government money is involved, most of these institutions are very well within the ambit of the Right to Information Act.
Thank you so much, ma'am. Over to you, sir. Siddhant, sir, please.
I just want to begin with saying that the right to information and the Official Secrets Act is something that's Professor Abha has quite eruditely covered. and my area of practice being privacy, I'm going to focus a lot more on that. The idea that privacy is only about preventing the King of England to enter in or encroach upon your home, or the idea that privacy as a concept is somewhat skewed because we have surrendered to large digital corporations or search engines, is somewhat antiquated and it sort of misguides the jurisprudence on the subject. Privacy is no longer a fringe human rights or civil rights concern for the primary reason that information and data has become the major denomination in which all social, economic, and political interaction takes place. The Aadhaar program, as well as its various ways in which government interaction has been enabled through the Aadhaar program, reveals one thing very clearly, that information is central to, in large measures even today, the interaction between citizen and government on a daily basis. And going forward, even between citizens and their daily life, whether it is operating a bank account, it is operating a mobile phone, or getting an internet connection. Online data and information technology is going to be enabling most of these things, as it is today, whether you look at UPI. Now, when information and data becomes central to the entire framework of socio-economic interaction, its protection becomes fundamental to the balance and stability of the entire framework. And therefore, privacy must be seen as that kind of concern today. Now, much has been said about the Right to Information Act and the amendments proposed under the Digital Protection Bill. But what ultimately, and also the impact the Right to Information Act has on corruption. I firmly hold this view that this absolutist idea of right to information is a blunt instrument to enforce public accountability. Right to information is not the only way in which public accountability can be enforced. It is an important and substantial way, but it's clearly not the only. So in order to, from a public policy perspective, there is a framework that is required which combines, in addition to right to information, internal checks and balances within government, vigilance mechanisms, strengthening prosecution. All these things must happen all together in order to enforce greater public accountability and to prevent corruption. The solution to corruption or the lack of public accountability can't be the sacrifice of privacy. Privacy going forward is going to be the fundamental bedrock of the rule of law, because most of your rights and your existence as a person and your ability to express your personality is going to be from the autonomy you have over your information or data. Privacy is not just about the protection of your information from disclosure. It is in essence an autonomy or a dignity concern. It is the ability of a person to decide to whom his data be used, for what purpose, and when it should not be used. And the entire idea is therefore to vest in individuals the choice of how to use their data. Now, having considered all of this, the Right to Information Act already had some checks and balances in terms of privacy, in terms of 81J as it exists today. The Supreme Court also in Girish Deshpande went into this question, where there was the question of whether income tax returns constitute information under the Right to Information Act. While there may be value in such information being given to prosecution agencies to enforce, say, corruption charges, but there can't be a blanket overarching disclosure requirement just because people may be government servants or related to government servants. There has to be an objective standard that is enforced across the board. And that is where I say that the importance of prosecution, detection, vigilance, internal checks and balances, internal audit requirements, all those things which are the fundamental nuts and bolts of administrative and governance reform have to be addressed. And our failure thus far to address those nuts and bolts governance reforms cannot be sort of compensated by a bludgeon on the right to privacy. And that's why it's a dangerous conversation in that sense to see privacy through this perspective as being the antithesis to transparency or public accountability. Having said that, what faces our entire existence today, in terms of whether you look at social media organizations, whether you look at the government collecting data, is centralization, is certain entities having a monopoly over data. And that is something that requires to be addressed so that data is administered in a way that is democratic, that is egalitarian, that respects the wishes and rights of people. Now, the Digital Protection Bill provides somewhat of that a framework. It's a principles based framework. It does not seek to regulate too closely online businesses, because we must remember that most of the last at least 20 years, the most valuable companies across the world have been based on data. Whether you see Facebook, Google, Apple, all of these, the most valuable companies of the last 20 years have been generated over over internet platforms and over personal data. Now, if India is to be a $5 trillion economy in the time to come, it will need to have a regulation that casts a balance, that doesn't regulate in a way that strangulates innovation, but also at the same time gives or affords protection to individuals to exercise their own rights. Now, that is the focus area, and the focus area of the Digital Protection Bill also to address the unequal bargaining power between the consumer and digital companies. And most often, actually, the right to information actually is a big component of privacy, and it is this. One of the central themes of the Digital Protection Bill and privacy in general in the last 10 years has been informed consent. That consent is premised on information. So when a telephone company or a bank or any other organization collects your data, it must say so in easy to understandable words as to what data it is collecting, for what purpose, and till what time. So the idea of informed consent and the right to information as a subset of privacy must also be appreciated. So these are the various concepts that we must look at, and these concepts can't be looked at in the way that one is antithetical to another. There are various overlaps, and that a composite framework, a sort of patchwork of rights, is what is needed, which will address the issues of public accountability, decisional autonomy amongst individuals, and the right to privacy. And I'd be happy to answer any question anyone has. Ritima, you may proceed.
Thank you so much, sir. So for the panel, we have few questions. You both can jointly give your responses. So the first question is, artificial intelligence shall play very expanding role in the data analysis and distribution. Human interface will be very pertinent. Can the speakers highlight their views?
May I, Ritima?
Sure, ma'am.
Yeah, so when we talk of freedom of information laws and vis-a-vis right to privacy, um, it's a murky field also, because I think there is some sort of disjointedness that we need to bring between freedom of information laws and to what extent they can help us when we talk of right to privacy, because we are entering into times now that we have a question about AI. I think it's apparent that RTI cannot solve AI issues, right? So yes, there will be privacy issues, but the thing is that when we talk of ease of doing business, when we talk of making sure that there is enough competition in the market, so there is the Competition Act for that, right? Which means that if you have digital platforms which are competing with each other, but there is a digital platform which is a monopoly, it is abusing its dominant position, then you cannot expect RTI to take care of that. You will have another legislation taking care of that. So what I mean to say is that privacy in itself it has so many multiple layers, right? So if we were to talk about, let's say, artificial intelligence, and artificial intelligence sort of disrupting the right to privacy. Should we rely on right to information to solve that issue also, is something I am rethinking. Because I think that would be something that probably the IT Act would take care of, or some other piece of legislation. But here, I think I would say that we are talking about a closed bureaucracy vis-a-vis rights of individuals as far as their personal freedom information is concerned. Um, and of course, personal data privacy is another bill, another huge area that's coming up. So those are concerns. These kind of concerns will be addressed in another piece of legislation, is all that I'm trying to say. But yes, the RTI Act also has a corner and a clash overlap with the right to privacy. But the dealing of that and the manner in which that will be dealt with will be very different. I feel the temperament would be different. Thank you. Maybe my co-panelists would have something to add to that.
Yes, if I may. The AI provides a unique solution to a number of privacy challenges. Once, because AI removes the human interface and therefore the possibility of leakage of data or of the usage of data in a manner that is unauthorized. So AI provides that solution where various activities can be done by feeding personal information without its danger of being leaked or disseminated. So while it may not be a ubiquitous complete solution, but with appropriate safeguards, artificial intelligence can be used for basic interactions between citizen and government and citizen in other economic interactions in order to eliminate or at least reduce the human interaction as well as the scope of error, the scope of the vulnerability of our systems in general as far as data is concerned. That's a very important question. Secondly, the looking at the right to information not just under the Right to Information Act but as a fundamental concept, AI also when AI is being used or applied on personal data, the person whose personal data is concerned must know what this AI is, and there must be accountability of what kind of AI is being used, what is its objective, what is its purpose, how will the data be treated, all of that. Now, for example, the manner in which news appears on a Facebook news feed, in the order in which you would see your friends' posts, is something that is determined by AI, and it is completely not accountable. It's completely opaque. Nobody really knows what's the objective basis, and that and as all of us have seen with Cambridge Analytica and the interference in the US elections, that it has a sort of profound ability to impact our polity. So on in both sides, AI may provide you with appropriate safeguards solutions to many challenging privacy questions. But on the other hand, in the absence of those safeguards, may pose a great risk to the very democratic fabric of our government.
And to add to what Siddhant just said, there are now major issues that even digital platforms are facing, from ChatGPT, let us say, or Bard, that is going to be the answer, so to speak, of ChatGPT. So while AI may or may not provide solutions, assuming that it is providing solutions, it is also posing challenges because there are no answers to the next level of technology that is facing us. So this is a never-ending debate, I feel. I mean, these are interesting times to be in, but also very challenging times, because technology is definitely, you know, it's coming at us from all sides at a pace with which we can't match. I mean, you come out with a regulation today, you come out with a bylaw today, and tomorrow your technology has changed, or yesterday probably it has already changed. So yeah, somebody just wrote CCTV surveillance, and that's a huge privacy issue in itself. So difficult questions to, very good questions, but I think time will tell how these challenges, legislations will be able to answer these challenges. But yes, I think these forums are important for us to deliberate. Thank you, Ritima.
Thank you, ma'am. Thank you, sir. We have another very interesting question. The participants ask how RTI role can impact CSR sphere.
if I may answer that, I think CSR is something that is a system that requires much more accountability, because given the benefits, whether indirectly, that corporations get, it's not like a usual thing where a government grant or government funds are extended to a particular entity, and that entity becomes subject to greater scrutiny. But this is where CSR contributions are made out of the profits of a corporation, and certain benefits accrue. And I think that this is something that should come within the ambit of whether it is RTI or other public scrutiny, to know what is the accountability of this expenditure, in the manner in which this expenditure is being made, to know that whether any of this expenditure is discriminatory in nature, which may violate the very values of the constitution that we seek to uphold. So I think CSR is a big area where more accountability, transparency, and a greater vigor of right to information is required to be enforced.
Yeah, I agree, Siddhant. And now it's not just CSR. Now we are moving into the ESG realm, which is even, it's a wider concept, environment, social governance. So ESG seem to be the overarching, the umbrella for CSR, and clearly as yet untouched um, by disclosures under the RTI Act. So how these international standards such as SASB, GRI, in ESG, how they will play out for companies. SEBI is of course the regulator, and it is doing what it can. But I think some sort of applicability of freedom of information laws there would help to bring in some transparency, because a lot of greenwashing um, is being done there also. But I don't know whether that would come with, in the ambit of RTI. I doubt it. Thank you.
Thank you so much. Thank you so much to both the speakers. And due to paucity of time, we'll wind up the session here and we will move to second technical round. So in the second technical round, we will be discussing jurisdictional scope, interface, and judicial trends from perspectives of media perspective, RTI activist perspective, and human rights perspective. For this session, we have an absolutely brilliant set of speakers. The first speaker for the session will be Mr. Shamlal Yadav, sir. Sir is a senior editor and member of the Investigative Bureau at the Indian Express and one of the pioneers of the effective use of RTI for investigating reports. The second speaker we have is Subhash Chandra Agrawal, sir. He is an Indian businessman and a right to information activist. He holds Guinness World Record for having written the most published letters to newspapers and editors. Sir's role in RTI is known to everybody. He has been the pioneer in the field. And then we have Mr. Venkatesh Nayak. Sir is director at CHRI and has been associated with the organization in various capacities since April 2000. He has been designated and conducted training programs for implementing RTI Act 2005 for senior middle-level officers of government is serving in various states. We are absolutely honored to have all three of them here on board with us. I request all the speakers for this session to please switch on their mics and cameras.
Okay, Ridhima, are you able to hear me? This is Venkatesh here.
Absolutely. You're audible, sir.
Thank you very much.
Subhash Agrawal, sir, are we audible to you?
Yes.
Perfect. Shamlal, sir? Okay, I think we have some... if Subhash, sir, can you go first as opening remarks?
Thank you.
Shamlal, sir, are you there? Just one cross-checking it with you. Okay. Subhash, sir, you can go, please. Thank you so much, sir.
थैंक यू रितिमा जी। मेरा आरटीआई का काफी तजुर्बा रहा है और 13 नवंबर 2019 का जो कॉन्स्टिट्यूशन बेंच का वर्डिक्ट था वो इट हैड अ ब्यूटीफुल कवर पेज। ऑफिस ऑफ चीफ जस्टिस ऑफ इंडिया कम्स अंडर आरटीआई एक्ट पर उसके साथ दो और केसेस क्लब थे। उसमें जो मैंने देखा कि सुप्रीम कोर्ट रजिस्ट्री को, यहाँ तक उस समय चीफ इंफॉर्मेशन कमिश्नर मिस्टर बिमल जुल्का को ये कहना पड़ा कि इन्हें आरटीआई की ट्रेनिंग की जरूरत है। उस दो केसेस में, एक में मैंने मांगा था कि मद्रास हाई कोर्ट के एक जज ने सुप्रीम कोर्ट के चीफ जस्टिस को लिखा था कि एक यूनियन मिनिस्टर ने मेरे को इन्फ्लुएंस करने की कोशिश करी। मैंने वो कॉरेस्पॉन्डेंस मांगी तो उन्होंने, और अल्टीमेटली कॉन्स्टिट्यूशन बेंच ने जो वर्डिक्ट दिया, उन्होंने कहा सेक्शन 11 का इस्तेमाल कर दिया जाए। अब सेक्शन 11 के इस्तेमाल में कमेंट्स मांगे जाते हैं, ना कि कंसेंट, और उसमें 10 दिन दिए जाते हैं कमेंट्स लेने के लिए। और सुप्रीम कोर्ट रजिस्ट्री ने क्या किया कि महीना भर तक जब कोई जवाब नहीं आया, 45 डेज तक कोई जवाब मेरे पास नहीं आया, जैसा सेक्शन 11 में प्रोविजन है, तो मैंने रिमाइंडर डाला तो उन्होंने सेक्शन 11 में जब नोटिस इशू किया, और उसके बाद वो सेक्शन 11 में थर्ड पार्टीज कंसर्न को रिमाइंडर्स पर रिमाइंडर्स देते गए, जबकि ऐसा कोई प्रोविजन नहीं है। अल्टीमेटली चलिए उस वाले केस में इंफॉर्मेशन अलाउ हुई, और जब मैंने टाइम्स ऑफ इंडिया में मिस्टर धनंजय महापात्र से कहा जी ये न्यूज स्टोरी बना दो, वो बोले अब क्या न्यूज स्टोरी बनेगी, ये तो 3-4 साल पहले हम पहले कवर कर चुके हैं। तो ऐसे आरटीआई एक्ट का फायदा क्या। दूसरा जो केस था उसमें था कि जस्टिस एपी शाह को सुपरसीड करने के ऊपर था। तो उसके ऊपर तो उन्होंने सेक्शन 11 में इतने कमेंट्स मांग लिए, घुमा घुमू के उन्होंने मेरे को नहीं दिया। और मजे की बात यह है कि जो चीफ जस्टिस उस समय थे, जिनके जो हेड थे कॉन्स्टिट्यूशन बेंच के, जब वो रिटायर हुए और राज्यसभा के मेंबर बने, तो उन्होंने हर एक टीवी इंटरव्यू में ये कहा, अगर आपको जस्टिस एपी शाह के सुपरसीड होने पे इंफॉर्मेशन चाहिए तो आरटीआई लगा दो। अरे आरटीआई तो उनके सामने ही थी, तो क्यों नहीं डिसाइड कर गए। तो इसलिए आरटीआई की ट्रेनिंग जरूरी है, दोनों तरीके से जरूरी है। मेरे को याद है जो इस समय के चीफ इंफॉर्मेशन कमिश्नर हैं मिस्टर वाई के सिन्हा, जब वो दिल्ली गवर्नमेंट देखते थे, तो एक केस में कि स्कूल के जो चिल्ड्रन थे, स्कूल के जो बच्चे थे, उनकी इंफॉर्मेशन सीआईसी के नोटिस के डर से पब्लिक कर दी गई। उन्होंने वहीं पर ही बहुत ज्यादा उन्हें कहा, उन्होंने कहा अगर इस तरीके से तुम मेरे बच्चे की इंफॉर्मेशन पब्लिक कर देते तो मैं तुम्हारे को कोर्ट में ड्रैग कर लेता। तो ट्रेनिंग दोनों तरीके से जरूरी है, जिससे पूरी इंफॉर्मेशन मिल भी जाए, और जो इंफॉर्मेशन नहीं देनी चाहिए वो नहीं। तो इसलिए ट्रेनिंग बहुत जरूरी है। और जैसा मिस्टर सुरेश चंद्र ने कहा,
technical problem from my side and was started. So please excuse me. I'm so sorry. And sometime else we will be together. Okay. Yeah. Thank you.
और जैसा सुरेश चंद्र जी ने कहा, इस समय सीआईसी की एफिशिएंसी बड़ी अच्छी हो गई है। अब एक 1-1.5 साल में नंबर आ रहा है, जो कि पहले जमाने में 4-4 साल में नंबर आते थे। मैं इसमें एक चीज और कहूंगा कि इसमें अभी एक ये भी सजेशन अभी मैंने सुना कि कुछ इंस्टीट्यूट्स को सीधे आरटीआई में लाना चाहिए। तो मैं कुछ, और होता क्या है कि कई पब्लिक अथॉरिटीज हैं, उन्हें सीआईसी पब्लिक अथॉरिटी डिक्लेयर कर देता है, वो हाई कोर्ट में जाके स्टे ले आते हैं, और फिर उसके बाद वो कभी स्टे खत्म ही नहीं होता। और सुप्रीम कोर्ट के बेंचेस ने भी रिपीटेडली कहा है कि हमारे जुडिशियल सिस्टम की ये वीकनेस है कि एक्स पार्टी स्टे ऑर्डर्स एंड एडजॉर्नमेंट्स आफ्टर एडजॉर्नमेंट्स, तो वो डिसाइड ही नहीं हो पाते। तो इससे अच्छा तो ये है कि कुछ अथॉरिटीज को ऑटोमेटिकली पब्लिक अथॉरिटी डिक्लेयर कर दी जाए। जैसे कि किसी को लैंड बिल्डिंग सब्सिडाइज रेट पे मिले, तो पहले उनसे ले लिया जाए लिखत में कि आप पब्लिक अथॉरिटी अपने आप को मानेंगे। और मैं आपको और एग्जांपल्स बताता हूँ कि सेंट्रल गवर्नमेंट ने भी पार्लियामेंट में कहा था कि नेशनल डेयरी डेवलपमेंट बोर्ड को सीआईसी के डिसीजन डेटेड 15 अप्रैल 2011 से अवॉइड करना चाहिए, जिसमें कि मदर डेयरी को आरटीआई में लाना चाहिए था। और आज तक मदर डेयरी आरटीआई में नहीं है। और इसी तरीके से उस समय के जो चीफ इंफॉर्मेशन कमिश्नर थे मिस्टर आर के माथुर, जो बाद में लद्दाख के लेफ्टिनेंट गवर्नर भी रहे, उन्होंने एक वर्डिक्ट में नोट किया कि इंस्टीट्यूट ऑफ बैंकिंग पर्सनल सिलेक्शन is not a public authority under RTI Act, even though 4 million candidates appear every year for examination conducted by it. इसी तरीके से cooperative joint IFCO, through which annual fertilizer subsidy of rupees thousands of crores is routed, gifted prime properties worth rupees hundreds of crores in New Delhi to its office bearers, with even CAG report pointing out massive irregularities in functioning of IFCO. Even then, IFCO is not a public authority under RTI Act. Like similarly, BCCI ने तो CIC की हियरिंग को चैलेंज कर दिया। फुल बेंच हियरिंग हो रही थी, उसके हियरिंग को चैलेंज करके कोर्ट से स्टे ऑर्डर ले आए। अब BCCI में किसका पैसा है? सब पब्लिक मनी है। इट इज ए पब्लिक क्रेज जिसका मनी उनके पास है, और वो एक एक कोच को 10 करोड़ रुपीस पर एनम तो सैलरी दे रहे हैं। क्लास ए क्रिकेटर को 7 करोड़ पर एनम की सैलरी दे रहे हैं, लाइफ टाइम पेंशन दे रहे हैं, और अवार्ड मनी, मैच मनी, वो सब उसके अलावा है। तो ऐसी इंस्टीट्यूशंस को तो ऑटोमेटिकली पब्लिक अथॉरिटी बनाना चाहिए। और मेरे को याद पड़ता है उस समय के जो चीफ जस्टिस थे मिस्टर RM लोढ़ा के सामने जब केस गया, तो उन्होंने पूरा वर्डिक्ट इस तरीके से लिख दिया था कि BCCI शायद पब्लिक अथॉरिटी बनने जा रही है, और एंड में उन्होंने गवर्नमेंट ऑफ इंडिया को सजेस्ट कर दिया कि आप इसका स्टडी कराइए कि शुड इट बी पब्लिक अथॉरिटी और नॉट। गवर्नमेंट ऑफ इंडिया ने लॉ कमीशन को मैटर रेफर कर दिया, और लॉ कमीशन ने रिकमेंड भी कर दिया कि BCI शुड बी अंडर RTI एक्ट, पर वो आज तक नहीं है। इसी तरीके से पॉलिटिकल पार्टीज का जो मेरा केस था, मजे की बात यह है कि जिन पॉलिटिकल पार्टीज ने RTI एक्ट को पास किया पार्लियामेंट में, उन्होंने ना तो वर्डिक्ट को ऑब्जे किया, और ना ही वर्डिक्ट को चैलेंज किया, ना लेजिस्लेशन अमेंड किया, और आज तक वो ऑब्जे नहीं कर रहे हैं। हमें ही सुप्रीम कोर्ट जाना पड़ा कि आप इसे इम्प्लीमेंट करा दीजिए। तो इस तरीके की चीजें बड़ी नोट करने वाली हैं। टाइम क्योंकि बहुत कम है, इसलिए मैं और चीजों पे भी ज्यादा ध्यान देना चाहूंगा कि RTI का मिसयूज बहुत बढ़ गया है। मैं NCPRI से सहमत नहीं हूं कि मिसयूज इतना नहीं है जितना कहा जा रहा है। मिसयूज बहुत बढ़ गया है, इसको मिसयूज को रोकना चाहिए। उसके लिए सबसे पहला काम तो ये करना चाहिए कि हर एक RTI एप्लीकेशन के साथ ID प्रूफ कंपलसरी होना चाहिए, जैसा पंजाब हरियाणा हाई कोर्ट का ऑर्डर है इन द केस फ्रूट मर्चेंट यूनियन वर्सेस अननोन के केस में। अब जो NGOs हैं वो कहते हैं इससे तो आइडेंटिटी डिस्क्लोज हो जाएगी। आइडेंटिटी तो पहले ही डिस्क्लोज्ड है, सिर्फ उसे प्रूव करना है। आपको जान के ताज्जुब होगा कि मेरे नाम से कम 50 फेक RTI एप्लीकेशंस लग चुकी हैं, क्योंकि एक परसेप्शन लोगों के मन में है कि शायद सुभाष चंद्र अग्रवाल के नाम से RTI जाएगी तो जवाब जरूर मिलेगा। और बड़े अफसोस का विषय है कि वो मिसयूज है टोटल। उसमें दो अफसरों की एक ही ऑर्गेनाइजेशन में दुश्मनी होती है, वो दूसरे को टारगेट करते हुए मेरे नाम से RTI लगा देता है, क्योंकि वो इनसाइडर होता है तो वो उसकी कॉपीज भी उसे मिल जाती हैं। एक ने तो मेरे ऊपर डिफेमेशन के केस का नोटिस तक मेरे को सर्व कर दिया कि आपने मेरे को बेईमान टारगेट कैसे किया। तो ID प्रूफ कंपलसरी हो जाए तो हर्जा क्या है? और उड़ीसा ने मान लिया ये वाली बात, पंजाब हरियाणा मानते ही हैं, तो थ्रू आउट द कंट्री ये बात माननी चाहिए। दूसरा ये जिससे कि मोस्टली NGO सहमत नहीं है, मैं कहता हूं कि 2005 में 2 रुपए का प्लेटफॉर्म टिकट था, 2 रुपए का एफिडेविट था, हर एक गवर्नमेंट फीस बढ़ गई। तो RTI फीस को भी 10 रुपए की जो बिल्कुल नेग्लिजिबल फीस है और BPL कैटेगरी के लिए निल है, तो RTI फीस को 50 रुपए कर दिया जाए, पर पेटिशनर को 10 ही रुपए पड़ेगी। क्योंकि मेरा सजेशन साथ में ये है, फर्स्ट 20 पेजेस फ्री ऑफ कॉस्ट दिए जाए। इससे पब्लिक अथॉरिटी और पेटिशनर दोनों का टाइम एंड मनी दोनों बचेगा, कॉपिंग चार्ज मांगने में और एमिट करने में। तो ये एक महत्वपूर्ण सजेशन है। तीसरा ये, पोस्टल ऑर्डर सब जगह उपलब्ध नहीं है, तो RTI स्टैंप निकाल दिए जाए। CIC ने एडमिनिस्ट्रेटिवली भी लिख लिया डिपार्टमेंट ऑफ पोस्ट को, और कम से कम 6 ऑर्डर इंक्लूडिंग 1 फुल बेंच ऑर्डर भी इसके ऊपर आ गए कि RTI स्टैंप निकाले जाए। जैसा कि कुछ लोगों को पता होगा कि एक जमाने में रेडियो लाइसेंस फीस के स्टैंप होते थे, उस तरीके के RTI स्टैंप निकाल दिए जाए, जो कि बड़े आराम से मिल जाएंगे, 2 रुपए, 10 रुपए पर 50 रुपए के। तो वो बड़े आराम से सब जगह उपलब्ध हो सकते हैं। डिपार्टमेंट ऑफ पोस्ट ने वो हमारी रिकमेंडेशन मान भी ली। उन्होंने SPMCIL को लिखा, सिक्योरिटी प्रिंटिंग मिल को, उन्होंने कह दिया कि RTI स्टैंप छापने के लिए पेपर उपलब्ध नहीं है। मजे की बात यह है, पोस्टल नॉर्म्स के अगेंस्ट जिंदा व्यक्ति पर स्टैंप छापने के लिए उनके पास 20 दिन के अंदर डिसीजन टेकन के कागज उपलब्ध हो जाता है। पर जो स्टैंप करोड़ों रुपए बचा सकता है, आपको पता है 10 रुपए की जो फीस है इसके पोस्टल ऑर्डर की, इसकी हैंडलिंग कॉस्ट डिपार्टमेंट ऑफ पोस्ट को 50 रुपए है। इतनी बैंकिंग सिस्टम में पड़ जाती होगी और इतनी पब्लिक अथॉरिटीज को कई जगह एंट्री होती है। तो उससे जिससे करोड़ों रुपए बचता है उसके लिए उनके पास कागज नहीं है। अजीब बहाना है। तीसरा मेरा सजेशन ये है कि बहुत कम लोगों को मालूम है कि हमारे देश में करीब 1,60,000 पोस्ट ऑफिस में से करीब 4,500 पोस्ट ऑफिस में ये सुविधा है जहाँ पोस्ट फ्री RTI एप्लीकेशन ली जाती हैं, और ये अधिकतर लोगों को नहीं पता। मेरा सजेशन है कि ये सुविधा देश के सभी पोस्ट ऑफिस में उपलब्ध करा दी जाए। हर एक छोटे से छोटे पोस्ट ऑफिस से रोज शाम को एक पोस्ट बैग बड़े पोस्ट ऑफिस जाता है, जिसमें रिवेन्यू मटेरियल और जो कैश कलेक्टेड होता है वो जाता है, और जो रजिस्टर्ड पोस्ट होती है, स्पीड पोस्ट होती है, वो जाती है। अगर 2-4 एप्लीकेशन आएंगे वो भी पड़ जाएंगे उसी में। तो पोस्ट फ्री RTI एप्लीकेशन जो हैं इस तरीके से हो सकती है। चौथा सजेशन ये है कि हमारी जो सेंट्रल वेबसाइट है DOPT की, वो बहुत अच्छी है, और पर कुछ राज्यों में जैसे उड़ीसा है, उनकी जो ऑनलाइन वेबसाइट है वो बिल्कुल बेकार है। उसमें क्या है कि वो कहते हैं ऑनलाइन वेबसाइट पे अपलोड करके फिर उसकी प्रिंट निकाल के और फिर उसे स्पीड पोस्ट से भेजो। तो ऐसी ऑनलाइन वेबसाइट का फायदा क्या? तो जो हमारी वेबसाइट DOPT ने बना रखी है NIC के थ्रू, वही वेबसाइट सब स्टेट्स पे होनी चाहिए। उसमें एक सुधार होना चाहिए, उसमें यह है कि SMS अलर्ट, ईमेल अलर्ट कुछ पब्लिक अथॉरिटीज भेजती है, कुछ नहीं भेजती है कि आपका RTI रिस्पॉन्स तैयार है, आप जाके देख लीजिए। तो जब ईमेल दिया हुआ तो ऑटोमेटिकली रिस्पॉन्स ईमेल से ही आ जाना चाहिए, बजाय हम जाके वेबसाइट पे स्टेटस देखें। तो ये थोड़े बहुत सजेशन है, अगर ये इससे मिसयूज भी घटेगा और RTI में सुविधा भी होगी। और इस तरीके के मेरे ये अनुभव हैं। और वेंकटेश नायक जी जरा ज्यादा इन्होंने रिसर्च पेपर्स तैयार कर रखे हैं, टाइम आपके पास कम है, तो मैं तो आपसे रिक्वेस्ट करूंगा कि वेंकटेश नायक जी को ज्यादा टाइम दीजिए। कोई क्वेश्चंस हो तो मैं लेने के लिए तैयार हूँ। थैंक यू।
फिलहाल तो अभी कोई क्वेश्चन नहीं है, आगे आएगा तो मैं आपको बिल्कुल बताऊंगी। वेंकटेश सर प्लीज।
थैंक यू वेरी मच रिधिमा, बहुत बहुत धन्यवाद ASSOCHAM को मुझे यहाँ पर आकर बोलने के लिए आपने एक मौका दिया। I'll try and keep my intervention as bilingual as possible because that is what I'm most comfortable with. Let me start with something very basic and stick to the topic which I have been assigned, which is jurisdictional scope, interface, and judicial trends on the right to information, right to privacy from the human rights perspective. क्योंकि ह्यूमन राइट्स पर्सपेक्टिव के बारे में मुझे स्पेसिफिकली बोला गया है बोलने के लिए, तो काफ़ी सारी बातें जो पहले के वक्ता ने जो बताए उनको एड्रेस करने का मुझे मौका मिलेगा और मैं उसके लिए शुक्रगुजार हूँ। You know, we heard things like government funds. We heard presentations on transparency as an essential value of governance, accountability being necessary, and how RTI is not the only method to ensure transparency and accountability. I agree with all of them, but what I would like to point out is this: transparency is much more fundamental than what we would actually want to or choose to understand. And let me start with the analogy of the sector that most of you know best, of which I know very little, and that is the market. जब से हमारे इकोनॉमीज मार्केट डोमिनेटेड हो गए हैं. Production has become for the purpose of market rather than for local consumption or subsistence. You are all participants in that market. Access to information becomes crucial for participating in the market. I do not want to elaborate on this, but you will understand what I'm saying. A market will not be a market if you do not have access to information and equal access to information. How will a buyer interact with a seller? How will a seller interact with a distributor? How will a producer interact with the consumer? Access to information is that central. Now I draw that analogy to democracy. If you accept the most popular and very simply worded definition of democracy, which President Abraham Lincoln gave in his Gettysburg Address, it is a government of the people, by the people, for the people. He didn't define it that way. That was the last sentence with which he concluded his very short 2-minute address. So if government of the people, by the people, for the people is what we understand as democracy, then transparency simply cannot be a value that determines the relationship between government and the governed. I am sorry, I cannot accept that position. If you accept that democracy is what it is as defined, then citizens become the primary and equal stakeholders in a democracy. Public funds which are contributed by taxpayers like you and me will not remain government funds, they will become public funds. And therefore, the information that government bureaucracies, public authorities, officials create, use, store, and legitimately or illegitimately destroy eventually. We'll not get into that argument. Government does not own those files. Government does not own the information in those files. Government is merely the custodian of that information. They hold it for us. Tomorrow they will retire. Perhaps one of your children or grandchildren will occupy that position. They become the custodian. This is something that is crucial that we need to understand as far as the fundamental importance and value of transparency is to a democracy. We have to start from there. Otherwise, we will not be able to address adequately what is presented, and quite rightly, as my previous co-panelist said in the previous session, the artificial conflict between right to privacy and right to information. It is not an either-or situation. You would be very surprised to know that the right to privacy is not a new concept. In India, let me make that very clear. The right to privacy was first mentioned not in those words, but the right to be left alone in what is called the Commonwealth of India Bill in 1895 that was drafted for the country as a possible constitution under the aegis of Bal Gangadhar Tilak and Annie Besant and others. उसमें right to privacy का mention मिलता है. And then in the 1920s, more constitutions for the country are drafted. Swaraj report is there. Nehru Committee report is there. Several other such documents are there. They all mention right to privacy in some way or the other. And believe you me, in the Constituent Assembly, there was no debate on the right to information. वो तो उठा ही नहीं right to information, because the understanding was अंग्रेज चले जाएंगे. 47 के बाद तो जाने वाले ही थे. The last had to be put on ships and sent away. तो अपनी सरकार है तो पारदर्शी बनेगी ही बनेगी. But the debate that took place in the Constituent Assembly was on the necessity of having the right to privacy. And I will not go into the details. There were many people in favor of it. There were many people against it. Eventually, the advice of the advisor to the Constituent Assembly, Sir B.N. Rao, prevailed, and they dropped the right to privacy as a fundamental right from being listed in Part 3 of the Constitution. For a variety of reasons, we will not get into that right now. But at that point of time, the right to privacy had a completely different approach, and something which Advocate Siddhant touched upon. It was more about the right to be left alone by the citizen without undue, unlawful, illegitimate, illegal interference by state or state actors. the idea of informational privacy or protection is of recent vintage. उस जमाने में वो था नहीं. थोड़ा बहुत इधर उधर राइट टू इंफॉर्मेशन, सॉरी इंफॉर्मेशनल के बारे में कुछ जजमेंट्स हैं, जैसे मिस्टर एक्सन वर्सेस हॉस्पिटल जेड, एक एड्स के संबंध के केस में, जहां पर इंफॉर्मेशन शेयरिंग को लेकर प्राइवेसी के बारे में चर्चा हुई थी. बट अदरवाइज इंफॉर्मेशनल प्राइवेसी वाज सर्टेनली नॉट central to the debate on right to privacy. The right to privacy as a fundamental right, as a deemed fundamental right, 1970s onwards, Gobind versus State of Madhya Pradesh and so on beyond, comes in the context of the obligation of the state not to interfere by making unannounced visits, unauthorized visits to people's houses, sharing information from their bank account to other people unauthorizedly, or conducting surveillance on them in an unauthorized manner, illegal manner. वो सारी चीजें थी. It was a negative obligation. What Justice Puttaswamy judgment of the 9-member bench of the Honorable Supreme Court does is it recognizes the positive nature of this right and the positive obligation of the state. What is that? The positive nature of the right is my right to determine how will and how much of information relating to me will be collected by private sector or public sector, how it will be used, how it will be stored, for how long it will be kept there, and for a regulatory authority that will determine the contours or the framework within which these rights and duties are going to be negotiated and implemented. So it becomes a positive obligation. But what is interesting for me, very interesting, is that the gentleman who represented the government of India before Puttaswamy bench, the constitution bench of the Supreme Court in the Puttaswamy matter, vehemently for several days argued that there is no such thing as right to privacy as a fundamental right in our constitution. For the last 1 week, the same gentleman today, as a lawyer supporting the petitioners in the same-sex marriage case, he is canvassing for the right to privacy in such a strong way, it even drew comments from one of the judges on the constitution bench saying, sir, we remember in the Puttaswamy case, you seem to be on the other side. And today you are batting for right to privacy. And of course, being a professional lawyer, he has to take his brief and he has to argue for his clients. So that is understandable. So what I'm trying to show is the journey that the right to privacy has made. And what is also interesting about the Puttaswamy judgment is the right to privacy is not recognized simply within the ambit of Article 21 of the Constitution, which recognizes the right to life and liberty, which is inviolate, except by due procedure of law. Subsequently, it has been clarified in various judgments that it also means due process. हम उसमें नहीं जाएंगे. But सुप्रीम कोर्ट ने बोला केवल 21 का ही हिस्सा नहीं है राइट टू प्राइवेसी, ये आर्टिकल 19(1)(d), 19(1)(e) में भी आता है, राइट टू फ्रीडम ऑफ मूवमेंट, राइट टू असेंबली, राइट टू कैरी ऑन प्रोफेशन. आर्टिकल 20 में नॉन सेल्फ इंक्रिमिनेशन, कि अपने खिलाफ मुझे गवाही देने के लिए मजबूर नहीं करने का अधिकार सरकार को नहीं है या पुलिस अफसर को नहीं है. एंड आर्टिकल 25 फ्रीडम ऑफ कॉन्शियंस एंड फ्रीडम टू प्रैक्टिस रिलीजन ऑफ वन चॉइस, इन सब का एक हिस्सा है. तो आज के तारीख में अनफॉर्चुनेटली विटिंगली और अनविटिंगली एक सोच बन गई है कि आर राइट टू प्राइवेसी जो है आरटीआई से बड़ा है. आई वुड वेरी रिस्पेक्टफुली बेग टू डिसएग्री विथ दैट अंडरस्टैंडिंग. अगर आप गवर्नमेंट ऑफ द पीपल, बाय द पीपल, फॉर द पीपल वाला बेसिक प्रिंसिपल अगर मानते हैं कि डेमोक्रेसी की ये बुनियाद है, तो ट्रांसपेरेंसी के बिना तो डेमोक्रेसी चल नहीं सकता. और दूसरी बात, Supreme Court has said in a series of judgments that you cannot interpret or enforce or implement a fundamental right in a manner that extinguishes another fundamental right. ये कर ही नहीं सकते. Action has to be taken in order to give equal importance to both rights. कोई भी एक मौलिक अधिकार के एंजॉयमेंट में कमी नहीं आना चाहिए दूसरे फंडामेंटल राइट्स के प्रोटेक्शन की वजह से या प्रमोशन की वजह से या फुलफिलमेंट की वजह से. सो इफ वी कीप सम ऑफ दीज बेसिक प्रिंसिपल्स एट द बैक ऑफ आवर माइंड्स व्हेन वी डिबेट, Whether RTI is more important, is it a statutory right, or is right to privacy more important because it is located in different fundamental rights because Supreme Court has said so? Things become a lot easier. Now, the issue of, which again Advocate Siddhant and Dr. Abha also very, very nicely they also posited, that there is technically speaking no clash between these two rights, the way it is being made out by quite a few. And the way public perception is कि वो right to privacy वाले activists और RTI activists के बीच में लड़ाई हो रही है और सरकार बैठ के तमाशा देख रही है। जी नहीं, ये बात नहीं है। बात यह है कि कितने हद तक जानकारी जो RTI कानून में थियोरेटिकली उपलब्ध होना चाहिए, उसको राइट टू प्राइवेसी यानी डेटा प्रोटेक्शन लॉ, पर्सनल डेटा प्रोटेक्शन लॉ जो आप लाएंगे, उसमें कितना कटौती करने वाले हैं आप? दैट इज द डिबेट. Believe you me, I have looked at statistics published by the Central Information Commission, which is the single largest recipient of RTI applications in any given year across the country. States में इतना नहीं आता जितना सेंट्रल गवर्नमेंट में आता है. आजकल 13-14 लाख जितना RTI एप्लीकेशंस आते हैं. सबसे ज्यादा इस्तेमाल किए जाने वाले exemption for denying access to information is 81J of the RTI Act, which is protecting the personal information of an individual from unwarranted invasion of their privacy through disclosure. It is more than 38%, यानी 1/3 से ज्यादा rejections 81J के basis पे हो रहे हैं आज के तारीख में. And this has been the trend right from the beginning. Earlier it was somewhere in the range of 24-25%. It went up to about 38.8% in somewhere in the middle, 2015-16. Today it is back at 38.3. So the greatest concern for all of us is that increasingly personal privacy is being made the basis for rejecting access to what information? Not about your neighbor or my neighbor. Sorry, no. Information is being denied about public servants in a big way using 81J. And the case law on section 81J has developed in such a manner that much against the intention of Parliament in crafting the language of section 81J by subjecting it to a harm test, आज के तारीख में ये class exemptions बन रहे हैं. कैसे मैं आपको उदाहरण बताऊंगा. Section 81J, which protects personal privacy, says very clearly that if somebody asks for information through an RTI application about some other individual, unless the disclosure of that information has a relationship to a public activity or public interest, or where it may lead to invasion, unwarranted invasion of the privacy of the individual, वो RTI वो जानकारी नहीं दी जाएगी. और फिर थर्ड पार्टी प्रोसीजर वगैरह वगैरह वो आते हैं. विल नॉट गेट इनटू द कॉम्प्लिकेटेड पोर्शंस ऑफ दैट. नाउ द अनफॉर्चुनेट पार्ट इज कि जो हार्म टेस्ट लगना चाहिए कि क्या वाकई में जानकारी के खुलासे से कोई पब्लिक एक्टिविटी या इंटरेस्ट का बल संवर्धन नहीं होगा, या किसी के अपने प्राइवेसी का जो अपेक्षा है उसका हनन होगा, अनवांटेड इन्वेजन ऑफ प्राइवेसी. Now the case law itself, which has developed, and with the deepest respect to the honorable courts, particularly the Supreme Court of India, I must say that within the same judgment, the line of thinking, in my humble opinion, again with the deepest respect, is not really crystal clear. एक जगह कहते हैं कि 81J का प्रोटेक्शन इसलिए डाला गया है क्योंकि राइट टू प्राइवेसी इज इंपॉर्टेंट. जब तक आप ये नहीं जब आप ये दिखा देंगे कि किसी के पर्सनल जानकारी के खुलासे से उसका प्राइवेसी का हनन होगा या नुकसान होगा, तो वो जानकारी नहीं दी जाएगी, which is a fair position to take. But 3 pages later in the same judgment, और ये कौन सा जजमेंट है? This is a judgment in which Mr. Subhash Chandra Agarwal had asked for information about the practice of judges, whether they are disclosing their assets to the Chief Justice of India or not. एसेट की डिस्क्लोजर की कॉपी नहीं मांगी थी उन्होंने, डिक्लेरेशन की कॉपी नहीं मांगी थी. आर दे कंप्लाइंग और नॉट, बस इतना ही सवाल किया था और उस पर 15 साल का लिटिगेशन चल गया. तो उसी जजमेंट में 3 पेज के बाद यह बात आती है कि फला प्रकार की जानकारी पब्लिक नहीं की जाएगी जब तक पब्लिक इंटरेस्ट ना हो. सो व्हेन देयर इज अ हार्म टेस्ट, हाउ कैन यू कन्वर्ट certain classes of information relating to employment, educational qualifications, caste certificate, religious background, etc., as information that will be default exempt from disclosure? This is not the intention of the Parliament at all. पार्लियामेंट डिबेट्स को आप देखिएगा, मैं इसलिए कहता हूं because I had deposed before the parliamentary committee twice when the bill was under discussion, and we explained why is it important to have harm tests. Several other things we explained, I will not get into that. So unfortunately, in my, again, with deepest respect to the wisdom and the dignity of the majesty of our courts, I must say that this trend of jurisprudence to turn certain categories of personal information into information that is exempt by default is hugely problematic. Honorable Information Commissioner Suresh Chandra साहब ने भी एक जजमेंट का जानकारी जजमेंट के बारे में जिक्र किया, तलपाड़म. That also turns all information about cooperative societies into information that is exempt by default unless I can show personal interest. हालांकि 81J उस पर इस्तेमाल नहीं किया गया है, but it turns it into a default position. Thankfully, in the DAV public school versus I forget the name of the respondent, थोड़ा सा उस पोजीशन को रिस्टोर किया गया है, and I'm glad that that has happened. Now, for us, the challenge is simply this: to understand that look, people's right to know. डेमोक्रेसी का मेरा थियरी छोड़ दीजिए. एब्राहम लिंकन कौन है भैया? यूएसए का ग्रीन कार्ड चाहिए, लेकिन एब्राहम लिंकन साहब का सोच की जरूरत नहीं है. ठीक है, मान लेंगे. लेकिन हमारे अपने जजमेंट को हम देखते हैं. कम से कम ऐसे 2 हमारे सुप्रीम कोर्ट के जजमेंट्स आए हैं जिसमें people's right to know what government is doing is deemed to be a fundamental right under Article 21 of the Constitution, which protects life and liberty. It is not just 19(1)(a), which is about freedom of speech and expression. It's part of Article 21. This is Reliance Petrochemicals versus Indian Express and SR Oil versus Halar Utkarsh Samiti in Gujarat. दोनों सुप्रीम कोर्ट के जजमेंट से. तो जब एक फंडामेंटल राइट का राइट टू नो यानी राइट टू इंफॉर्मेशन और राइट टू प्राइवेसी दोनों उसके हिस्सा हैं, तो आप कैसे एक बिल लाकर बोल सकते हैं कि 81J को हम अमेंड करेंगे और इसको ऑल पर्सनल इंफॉर्मेशन विल बी exempt by default कर देंगे? That is not how you balance. So I do not want to go into the details of the data protection draft bill. Apar Gupta is here. There are other persons here who are much more competent to talk about it. I only want to end my intervention by making one clear distinction. And here I would very respectfully beg to differ with Advocate Siddhant. The protection of right to privacy as far as Indian jurisprudence is concerned is not available to private individuals and public servants on an equal basis. I'm sorry, I refuse to concede that position. In the R. Rajagopal versus State of Tamil Nadu judgment of the Supreme Court, and which has been recognized subsequently in several other judgments and reiterated in Puttaswamy, it has been said very clearly that the protection for information relating to public servants, particularly in the context of the discharge of their public duties, is of a lesser order. The protection is of a lesser degree than the protection of right to privacy that is available to purely private individuals. And this is where the battle is. कि जो जानकारी हमें चाहिए हमारे अड़ोस पड़ोसियों के बारे में, हमें जानकारी, उनका प्राइवेट जानकारी ज्यादा हमें नहीं चाहिए. ज्यादातर लोग जो मांग रहे हैं वो सरकारी काम करने वाले पब्लिक सेक्टर एजेंसीज में मौजूदा अधिकारी जो है, कर्मचारी जो है, उनके बारे में मांगे जा रहे हैं, क्योंकि वहां पर बहुत सारे समस्याओं का को झेलना पड़ रहा है लोगों को. And that is what needs to be factored in the debate on RTI, how much of transparency, and right to privacy, how much of protection for what kinds of personal information. So once again, I would like to thank ASSOCHAM, the organizers, and all of you for having thought it appropriate to invite me here. And I would look forward to engaging with you on ASSOCHAM and other platforms a lot more, because मैं भले ही RTI के लिए काम करता हूं, लेकिन I am primarily an Indian citizen who believes in the Constitution. तो हमारे फंडामेंटल राइट्स चैप्टर में जितने भी फंडामेंटल राइट्स हैं उन सबका प्रोटेक्शन मिलना चाहिए, not protection for one at the cost of another. That's where I will stop. Thank you very much.
Thank you so much, sir. And we have received feedback for both the comment section. Am I out of the comment section? Am I on?
Yes, I can hear you.
Hello.
Yes, we can hear you, Ridhima. At least I can hear you.
So, as I was saying, thanks so much for your assignment, having your results. We can for the conference. The session is right to privacy, and we have with us Mr. Kazim Svi, Mr. Apar Gupta, Director at Internet Commission, with us in Foundation. I invite both of the speakers to take over the start of the session, please. We can go with the parser taking the
Thank you so much for having me here. I hope I'm audible, Rituma.
You're audible, Apar. You're audible.
Okay, thank you so much. So, I had the benefit of hearing the remarks of the last panel, and a large amount of the comments made were focused on Section 81J of the RTI Act. And that sets a very good background to where Kazim and I hopefully will take this conversation. What should be the conception of a data protection law which protects individual privacy as well as satisfies the other governance objectives without undermining the RTI Act? And here, the first thing I'd just like to state is that the RTI Act by itself is not the only law which will be impacted by the data protection bill. And this is important for us to understand as lawyers, because quite often we see in laws there's a non-obstante clause, which is passed at the time when the law is made, which essentially makes it as a latter enactment which overrides all earlier ones. Now, this is somewhat distinct in the Digital Data Protection Bill, which is the latest version which has been proposed by government as the law which will occupy the field of data protection in India. Here, if you look at Section 29, it says consistency with other laws. The provisions of this act shall be in addition to and not be construed in derogation of provisions of any other law. So what this means is that unless there is a specific amendment being made in the Digital Data Protection Bill by itself, right? The other laws, if they are in conflict with the Digital Data Protection Bill, when it does become an act, this conflict will be resolved in favor of those laws. Both provisions will be harmoniously construed, or the provisions which are in conflict, which were in another earlier law, will be given priority. Okay, in that sense. Now, let me bring a tangible example. Why does this matter? If you have seen, there is a certain class of data under the Representation of Peoples Act, which is also made available to people, because it ensures that the electoral processes which are carried out are open to public scrutiny. We can check the electoral rolls and thereby ensure that the people who are voting in a specific locality are actually residents, are real people by itself, given that India historically had a problem with sanctity of our elections with respect to polling at the very first juncture itself. This is not to say that problems do not exist today, but transparency by itself is not a unique feature only to the RTI Act. And this is what I would like to indicate. It is spread across in several enactments. And here, what is the other thing I stated earlier initially was in terms of first principles is that the Digital Data Protection Bill does not override those other laws. So the Representation of People Act will continue to stand the way it is. The regulations which are made with respect to companies where their data is also available after payment of certain money to the MCA website will be available to people. However, a very broad category of public information is indeed serviced through the Right to Information Act, which does constitute the majority of the disclosures which are made. And here, the impact on the central enactment, not on the state enactments, because the states have also passed their own RTI laws, which apply to their instrumentalities. Here, it is important to consider Section 30, which notes specific amendments to other laws. And here, the amendment is for the omission of Section 81J and its proviso. Now, Section 81J, as people who may have been tuning into the outline provided by Venkatesh Nayak, is the provision in which disclosure of information may be prohibited when it relates to somebody's personal information if such disclosure is not weighed against public interest. So public interest is the overriding feature. Even if a person's personally identifiable information is asked under the RTI Act, under Section 81J, it can still be disclosed. And quite clearly, from what Venkatesh presented, there are problems in Section 81J. He stated that this is the possibly the section under exemptions which is utilized most often to prevent the proper disclosure of information. In fact, if you look at a report by the Satark Nagrik Sangathan, they state about 34 to 36% of the orders they analyzed were denied only under Sections 81J. And I can state that also as an advocacy organization, which sometimes seeks very, very simple information, such as who participated in the consultation, names of parties, not the actual submissions, or also the actual submissions in public consultations, that all this information is denied. And public consultations for the formation of public policy, which impacts all of us, not only one or two companies by itself. And these are the provisions which are used often. Now, one should actually think that if the digital data protection law is removing Section 81J, why should people have a problem? And this is a problem which has emerged over a period of time, where after the RTI Act has been passed, there's always been a sense of threat that it will not be implemented, it won't be serviced well, information commissioners won't be appointed, regular amendments have been suggested to water it down, etc., etc. And this has been done from the times of the UPA, in fact. So I think it's not only this fear or apprehension, it is that real basis in which privacy is being used in certain decisions like the Canara Bank, etc., where transfer posting information is not made available. Section 81J, even though it presents a barrier by itself, its removal will result in the Data Protection Authority becoming the default for determining all kinds of requests for information in which one will not know which regulatory authority, information commissioner, or a DBA, which way it will interact by itself, given that the regulatory body under the Digital Data Protection Bill also seems only to be an adjudicatory body, principally for data leaks. So I would say that there's a lot of vagueness today. But this is not only a fault of the Digital Data Protection Bill, even the draft which was suggested as the personal data protection bill by the Justice B.N. Sri Krishna committee suggested changes to the RTI Act, which were criticized by civil society. I'd like to end this intervention by stating that the objective of both the RTI Act as well as the Digital Data Protection Act actually are fairly complementary when one thinks about individuals and communities and the accountability they force towards public authorities. Both, in fact, allow individuals and groups, especially those who lack social and economic power, to conduct themselves with a degree of liberty, with a degree of freedom, with a degree of equality and dignity. And that is at the root of the RTI Act, in which people wanted a greater degree of scrutiny in terms of display of their muster rolls, how much wages they are paid, or with respect to data protection or privacy, where people did not want certain information to be compulsorily gathered by the government. I'll turn this over to Kazim, and before turning it over, one final thing I'd just like to add is that we have to think about both of these laws from the perspective of how they can complement each other, and this has been done abroad, and Venkatesh and the others are quite aware of it. In fact, some countries have constituted data protection authorities within the information commissioner offices, such as in the United Kingdom. I would not recommend for that in India, but I would definitely like to urge that rather than a framing of one versus the other, we have to think of both of them being complements to each other.
Kazim, sir.
Yeah, thank you. Thank you. First of all, thank you, Ritima, for inviting me. Thank you to ASSOCHAM. I've been listening in since I think an hour, and it's been great learning and really interesting discussions with respect to the intersection of right to information and right to privacy. I think speakers before me, Apar, Venkatesh, and others really sort of have elaborated some of the challenge which we are facing in India today with respect to the interaction of both these rights and whether these rights are complementary or conflicting in nature. In the interest of not repeating what has already been said, I want to focus a little bit on public interest versus private information and private interest and private information. And basically, what sort of want to distinguish between what is or what do we mean by public interest and where does one right start and the other right ends? Because as we all understand, and through Supreme Court's jurisprudence in the past, it's very clear that one fundamental right cannot be used to restrict the other right and vice versa. I think there are a couple of problems with the way that current digital data protection bill has been drafted, especially clause 29, which seeks to sort of amend A1J. And I think a lot has been said about with respect to how that will really curtail and dilute right to information. But in all of this, I think it's important to understand what are we really sort of trying to achieve with respect to public interest and what do we really mean by public interest. Right to information, as we know, was enacted to facilitate greater transparency on behalf of the government and how government is using the public resources, which includes public land, public money, public infrastructure. All these institutions where there is a role and a stake is owned by the people of India, right? The government, as we know, is for the people, of the people, and by the people. And due to that, the people deserve a right to understand how the government functions, how the funding with respect to the allocation of funds for different programs, how these things are carried out in the larger public interest. And therefore, the right to information was enacted to facilitate greater trust between the people and the government. And of course, the government which eventually represents the people. Now, while that was necessary, we've been also sort of looking at the evolution of right to privacy jurisprudence. And I must say that right to privacy does not at all conflict with right to information, because right to privacy is the right for non-disclosure of private personal information. Information which is restricted to a private individual in his private capacity, in his private interest, and it has nothing to do with his public function. For example, a bureaucrat, what he does in his house, he has a right to privacy, he has the right to non-disclosure, he has a right to safeguard his interest. But what he does or she does when they are performing the job of a bureaucrat, which is a public office, is a different ballgame altogether. And I think over there is definitely a need for transparency and greater accountability with respect to the people. Now, if we're bringing in a law, which is the current data protection bill, number one, on the technical side, I don't think it is technically possible for a bill which is only looking at digital data to be able to say that any information which is of personal information will be denied to be provided under the Right to Information Act and the dilution of 81J, because right to information includes both offline and online data. So number one. Number two, as previously mentioned also, we don't believe that one particular law can seek to dilute the right provided under a different law. And both the laws are trying to sort of enhance and operationalize a fundamental right at the end of the day, which also is not, in my opinion, possible to do. And I think the third point is around the intersection of public office, public interest, and private interest, seeking disclosures, seeking transparency, seeking accountability is within the legitimate right of the people of India, while at the same time there are certain barriers and certain restrictions, because as we all know, fundamental rights are not absolute. But to deny information stating that under right to privacy law you cannot access that information, it impinges on the right to privacy, is technically incorrect and could be challenged in constitutionally going forward. And moreover, I think it's important for us to understand that whatever is in public interest is desired and is supposed to be disclosed as much as possible to ensure and enhance trust of the people. Now, if we start withholding information by using a different law and a different means, I think that would really, really sort of curb the right to information. It would really impact the trust factor with the people. And I think it would also sort of really, make the Right to Information Act less impactful. And I don't think trying to achieve lesser accountability under one law using a different law is the right way forward.
Thank you so much. We have few questions from the participants, and since we also have Venkatesh sir here, so if all three of you can jointly answer few questions. First is why RTI cannot answer questions on transparency in matters of human rights, NGOs and associations.
Okay, since the other panelists are not responding, very briefly, let me say that no, the right to information has been used to seek information about NGOs, about corporates which are in the custody of public authorities. It is just that the right to information cannot be used to seek information from such non-government bodies. When I say non-government, I'm not talking about NGO, I'm talking about bodies that are outside of the government sector. So you cannot use the right to information directly to seek information from them. But otherwise, we have received, many of us have been using the right to information to ask information about a whole range of activities of private entities from the public authorities who regulate them, be it private sector entities or social sector entities, or sometimes even individuals. So, and all in relation to the functions of the state, and not like, I completely agree with what Mr. Rizvi and Apar have said, that this is the bill on data protection is about protecting the purely personal information in the personal domain of an individual. And it should not extend to their public roles and responsibilities if they are performing one.
Do we have any further comments on this? Apar sir, Kazim sir?
So I think largely, even if the RTI Act were to be amended, I think it should be done through the process of amending the RTI Act and not using a different law to sort of bring an amendment into the RTI Act. Number one, I'm not sure if technically that is the right way to do. Number one. I think number two is around the fact that where do we draw the line between public and private? And I think there is enough case laws to sort of dictate us and sort of explain to us where that line has to be drawn. But I think it's very easy to distinguish and determine, when with respect to the usage of publicly held infrastructure and public offices. And I think there are a lot of case laws, and there's a lot which has been done in the past to sort of help us get there. Now, where is personal information disclosure of personal information detrimental to public interest? That is a question which we need to ask. And I think there is a need to sort of go into explaining whether there is detriment, whether it detriment the sort of the public interest if private information is disclosed, to what extent, because at the same time, bodies can also seek exemption under the data protection law. So I think it's at this stage, what clause 29(1) is trying to achieve may not stand the true test of necessity, proportionality, and legality, which are certain restrictions and certain sort of ways where the state can seek exemption. But I don't think refusing information within the public interest would meet that criteria.
We have another interesting question. The participant asks if corruption in spending of CSR funds, there should be both commercial or social audits for this.
Well, I think the short answer is yes. But in response to the previous question, I wanted to just give an example. And this is something that I learned about 18 years ago when we organized the first National Implementation Conference on RTI in June 2005, and we had invited the Deputy Information Commissioner of the United Kingdom. And one day when we, one evening when we took him to Kareem's at Chandni Chowk, he gave an example of how to understand privacy and public interest. He said, look, the residential address of the Prime Minister of the United Kingdom is number 10 Downing Street. It is definitely personal information as far as the occupant of that office is concerned. However, where does the Prime Minister of the United Kingdom live is a matter that carries enormous public interest. And despite the fact that it is personal information of the incumbent of the PM's office, people have the right to know where that person lives, because he's occupying or she's occupying the post of the United Kingdom. So it's those kinds of simple things which, unfortunately, and I must say this again with the deepest respect to the judiciary, we don't see such kinds of discussion on elementaries in our case law on the right to privacy. It's being turned into another sacred cow. Unfortunately, that is not how it should be. I'll stop here.
Last question for the conferences: if human rights aspects are adequately integrated with RTI?
I'm sorry, the question is not very clear to me. What exactly are they asking?
So the question reads, if human rights aspects are adequately integrated with RTI. I believe if they are asking the lives of RTI activists and their protection is covered in the RTI Act.
Well, unfortunately, it is not. And even the Whistleblowers Protection Law passed in February 2014. We are now 9 years down the line. It has not been implemented. And in the meantime, activists who use right to information, even citizens, first-time users, have also been targeted. Now, this is where governments actually have to show the initiative of recognizing this phenomenon of attacks on transparency advocates, anti-corruption activists, social justice activists, and make sure that that phenomenon is rooted out. Otherwise, the national motto which we carry in our pockets every day on the coins and on the currency notes, Satyameva Jayate, that will just remain words and nothing more.
Thank you so much, sir. Thank you so much, Apar sir and Kazim sir, for your time and sharing your knowledge with us. It was wonderful having all of you here with us. With this, we wind up this technical session. And next we have is Raj Krishna. He will be summarizing sort of all the three inaugural session and all the three technical session and the inaugural session. And if Raj, you have any questions with us for the speakers.
Am I audible?
Absolutely. Please go ahead.
So it was quite an interactive session, and I'm thankful to the ASSOCHAM for inviting me here. So we had three different sessions, wherein in session 1, we discussed about the struggles behind, we had a discussion upon the struggles behind the RTI enactment, how from the grassroots level, it rose up and the act finally came into existence. However, the most astonishing point was that the mention about the Canadian case, wherein the trial took place in camera, in privacy, which affected the public at large. It is quite an interesting thing to see, because hardly we see such incidences happening all over the world. So this is something which one should learn of, because if a right of an individual is affected, it's not sure that it won't happen to if particular is affected, it is not sure that it won't happen with us. Secondly, as we looked into it, that whether in the session 2, whether the RTI officials are well equipped, well trained to deal with these issues, because as Subhash sir pointed out, that the delay which happens in getting information of even primary nature, this raises a serious question upon the functioning of this office, because if it is so difficult to obtain information under the RTI Act, then the whole objective of getting this act is of no use if it is not functioning so smoothly and properly. Furthermore, in the session 2, we also had a very brilliant discussion by Venkatesh sir regarding the human rights perspective, where he discussed about the Article 21 perspective and Article 19 perspective together, along with Article 20. So, which I found it very astonishing, very interesting, was that if you look into the privacy jurisprudence of our country, it reflects around the Puttaswamy verdict, the main case of our right to privacy history. But we need to look into one aspect of it, that that particular case was about the action of a state against the individual, whether state can intrude an individual's act or life or not. And the Supreme Court propounded a proportionality test to check whether it can be done or not. And on the basis of it, the Aadhaar Act was upheld. But in cases like Office of CJI or any other public office, wherein the individual is seeking information and it's the state which has to provide, there is no balance of power between the two. So applying proportionality test in such a place seems a bit absurd, because there is imbalance of power. Furthermore, in session 3, as we had discussion on RTI and privacy regarding the data protection bill, the various boards, and in regard to consistency, we have a chief information commissioner and information commissioners along with it. And secondly, we also are looking for a data protection body, a board. Who will look into it is a different question altogether. But these institutions are very important because they are acting as a bulwark of between the imbalance of citizen and state. So the independence of these institutions are very important. So how much independence will be ensured by these legislation? One has to look into it, because we cannot, because just making laws won't serve the purpose until it is not working properly. As it is said that justice must not only be done, but must be seen to be done. So if there is an organization, if it is working properly or not, that depends upon the actual functioning of it and how quickly it delivers a result. Because it is easy to point out that there is a misuse of RTI and stuff like this. But actually, is it so? Or is it just trying to shield a particular individual? Because if we look into the change, like in the pre-independence era, we were the subjects, but now we are citizens. Do the citizens don't have a right to know this so easily? Because these things should have happened from the inception itself, but it took so many years of struggle. So it will be quite interesting to see that how this will work out in these laws will work out in the future after the amendments. Thank you.
Thank you so much, Raj. Thank you so much for very well summarizing the entire session. With this, we close the conference, and I am immensely grateful to all the speakers here and the participants for spending their time with us. And it was wonderful having all of you here. We look forward to hosting all of you again in near future. And we thank our media partner, SEC Online, for their support in the conference. Thank you so much. Thank you, everyone.